And the very last thing we talked about yesterday was tenancy by the entirety and joint tenants as they are in North Carolina. So this last section is just kind of specific to us here. So any questions about tenancy by the entirety or joint tenancy? You guys might want to go ahead and get your chats ready. I'm going to be asking you guys some questions today. So if you want to send just me a chat. So since you guys are all ready, what do we know about caveat emptor? Tell me something about caveat emptor. What do you think of?
Buyer beware.
Buyer beware. Caveat emptor, we're referring to buyer beware. So we know what it means, right? It's Latin and loosely translated, it means let the buyer beware. But what does it actually mean? So we need to make sure that we're good on that. So buyer beware, caveat emptor says the seller has no duty to disclose information about the property being sold. Let's say that again. The seller doesn't have to disclose anything. Okay. The only exception that I've ever been able to come up with, and you guys will talk about this in, I think it's 301, is lead-based paint. The seller is obligated, if they know of a presence of lead in the home, they have to disclose if they have any reports or records. So if they've had it remediated or tested, then they are to provide those. That's more of a federal thing than a state thing, though. So there's EPA rules and guidelines with lead-based paint. Where are my HGTV fans? Come on, I know you're out there. There you go. All right. You know your friends, Chip and Joanna, your house flipper friend, they got themselves in trouble because they violated EPA's guidelines with lead-based paint. You guys remember this a couple years ago? So, you know, even reality TV stars have to follow the rules. But anyway, we digress. So for the most part, the seller has no duty to disclose anything about the property, which puts the burden of discovery on the buyer. Hence, buyer beware. The due diligence period in our offer to purchase and contract is the answer to buyer beware. Why does this buyer get this opportunity to investigate the property and learn everything that they possibly can about it? Because buyer beware. Does that make sense to everybody? So the seller has no duty to disclose. However, this does not give the seller a free ticket to lie. Okay, they don't have to disclose, but they still can't lie. We're going to look at our residential property disclosure in just a second. So the buyers are expected to do their inspections, discover for themselves any issues or defects with the property. First off, there's no such thing as a perfect house. It doesn't exist. Even brand new construction, where they just slap the doors on and put the finishing touches on today, it's still not perfect. People build them. Yes, people make mistakes. So all buyers are encouraged to have an inspection, even new construction. Why would they not? Right? But that's what buyer beware does. Again, it puts the burden of discovery on the buyer. And guys, when buyers hire us as their agent, we're taking on that responsibility with them. So when we're working with buyers, if they want to investigate this or inspect that, don't look at your buyer and say, no, it's fine. You don't need to get that tested. If it's important to our buyer, then it should be important to us. And if it's important enough for your buyer to say, I want to have this tested, I want to have this inspected, I want to have this investigated, then our answer to our buyers need to be, okie doke, let's do it. Okay. Please don't look at your buyers and say, I hope this is all a joke, but I've heard stories in the past about concerns about lead-based paint. And people have said, just tell your kids not to lick the windowsills and they'll be all right. No, that's not what we're going to say. If they say I have concerns about lead-based paint, then we're going to help them get that inspected, get that investigated. Okay. We don't get to follow caveat emptor. caveat emptor only applies to the seller. We are bound by license law and commission rule to disclose material facts. I think this is the biggest conflict between seller and agent. I think this would be a bigger conflict than even commission. The seller possibly knows about the defects of their property, and they may or may not know that they don't have to disclose. And then here we come telling them that they don't have to disclose, but I do. Sellers don't like this, do they? Have you guys talked to sellers and they haven't really liked this? But remember again what OLCAR says, I follow my client's lawful instructions. And anytime I'm asked to violate license law and commission rule, I cannot follow those instructions. So when the seller looks at you and says the roof leaks, shh, don't tell anybody. I'm sorry, seller. I have a duty to disclose material facts to everybody. We're going to talk a little bit more about material facts. Any questions on this and our responsibility? All property in North Carolina is sold as is. There's a very important line in our standard offer to purchase and contract. It says this property is being sold in its current condition. What do you guys think it means when a home is actually advertised as is? Are they just being redundant? What do you guys think? You see a home as is.
Something's wrong with it.
Something's wrong with it. The seller knows.
The seller doesn't want to keep, the seller's not going to make any repairs.
The seller's not willing to do anything. We, maybe we know something's wrong. We know something's wrong with it, right? Because there's no such thing as a perfect home. When I see as is, again, it's kind of redundant, isn't it? Because we already know homes are as is. Can we ask? Sure. The worst they can say is no, right? But when they advertise as is, I tend to think, okay, buyer, the seller's not willing to do repairs. They're telling us. Now, can I still ask? Sure. If my buyer wants me to, who do I work for? So again, the worst they can say is no. The seller can't terminate because we ask, right? So the worst they can say is no. Didn't you read the MLS? We told you as is. All right. Just thought I'd ask. Please don't think or misunderstand or have a misconception that a property advertised as is does not negate the listing agent from having to disclose material facts. We always have a duty to disclose material facts. So even if the seller says as is and I'm not doing any repairs, that's still not an out for us. If y'all haven't written that down yet, please do. We always have a duty to disclose material facts. I don't care if you're my client or my customer. We always have a duty to disclose material facts. Everybody good with that? So let's talk about our North Carolina Residential Property Disclosure Act. We're going to talk about the forms in just a second. But the act is that requires the sellers to complete the disclosure forms. And these forms are interesting, aren't they? They are mandatory forms with optional disclosure, which means the seller has to complete them, but they don't have to disclose anything. They have the option to say no representation. Mandatory forms, the optional disclosure. Now, there are some exceptions. Not all sellers have to complete the forms. We'll talk about those exceptions in just a second. So the forms in particular, and again, we'll look at these. It's just easier for me to say RPODs and MOG. Our Residential Property Owners Association Disclosure Statement. You'll see that in writing in just a second. And then mineral and oil and gas rights. Again, we'll look at that in just a minute as well. Just an FYI, just for a history lesson for you. The form mineral and oil and gas right disclosure didn't exist until 2015. How old is that? That's not that old, is it? It used to be that the provision about mineral and oil and gas was actually a provision in the RPODs. But there was a court case that went down, so they pulled out that one provision from the RPODs and created a MOG, mineral and oil and gas rights. These are forms provided by the North Carolina Real Estate Commission, not NCAR. NCAR produces most of our standard forms that we use: offer to purchase, agency agreements, addenda, amendment. But these forms are provided by the Real Estate Commission and they cannot be altered in any way. They are what they are. So there's no point in calling an attorney to get them to draft something else up. These forms are what they are. And again, we're going to look at these in just a minute. So the rules of the Act says that the buyer has to receive the disclosure forms prior to making an offer. And what the buyer is signing with these forms is acknowledgement of receipt of the forms. They're not saying that they like the way it's complete. They're not saying that they're pleased with the fact that the seller said no representation. They're only signing acknowledgement of receipt. Remember, mandatory form, optional disclosure. So all the seller has to do is provide the form. They're free to complete it any way they want. Why? Caveat emptor. So the seller's obligation is to complete the form, provide it to the buyer prior to making an offer. For those of us in the Triad MLS, we know when we're active, we know that when we go out to show property, the majority of the time, I'm not going to say 100% of the time, but the majority of the time, these forms are loaded in MLS as an attachment. So we can generally see them before we ever view the property. Have you guys ever seen an RPODs, for example, shared it with your buyer and your buyers decided not to see the property because of the RPODs, because of anything that the seller disclosed? Yeah, I'm seeing some head shaking. I mean, I had one once, it was like, warning, black toxic mold, enter at your own risk, wear masks. This is before we all had masks, and I said something to my buyers and they're like, we don't want to go in there. And I was like, cool, thank you, seller, for disclosing that. We didn't go inside. But it can help, especially if, let's say, for example, your buyer is about maxed out on their loan approval. They're about maxed out on their savings account, the extra money they have to buy, and they can't afford to do a whole bunch of repairs. Then this form may help them decide if there's a whole lot of things that are broke or not working. This may help them decide if it's worth their time to see the property. What happens if the seller doesn't provide the disclosures? Well, basically, the buyer has an opportunity to cancel their contract. And if they cancel the contract due to failure of receipt of the RPODs or the MOG, they will get their earnest money and due diligence back. Now the rules say, and by the way, you can also find this verbiage in our offer to purchase and contract. The seller has to acknowledge receipt. The buyer has to acknowledge receipt. And they have this opportunity to cancel within the 3rd calendar day following receipt or the 3rd calendar day following contract formation, whichever one occurs first. Other kind of exceptions is if occupancy takes place prior to settlement. So think of like a lease to own situation. They may already be living there before they purchase the property. So obviously that would happen before. But this is have you guys ever had sellers dig their heels in about doing this? Because we show them this and it's kind of scary looking, right? The font is about that big. It's hard to read. And then they got to answer all these questions, or they can't have the choice to answer all these questions. And I think sometimes when we don't see them attached in MLS, I mean, it might be that the agent's trying really hard to get it, but the seller's just, oh, I'll do it after dinner. And then that comes and goes. And oh, I'll do it in the morning when I'm drinking my coffee. And you guys know how people can be sometimes. So what's the carrot? What can we do to make them do this form? We don't want to give our buyer an out. We don't want to give our buyer a reason to terminate. So just let your seller know failure to complete this form, failure to provide the form may be an out for the buyer. Questions on this? So when it comes to the forms, our general duties, well, we have a duty to inform our parties of their rights and obligations. We're actually going to see that on the form. Again, why recreate the wheel? They put that on there for us. So we'll see that in just a second. We're gonna make sure, we are all gonna make sure that the buyer gets a copy. Again, it's gonna be in most of the time an attachment in MLS if it's listed at MLS. What if it's a for sale by owner? Do FSBOs still have to do the RPOs? Listen to us. Does a for sale by owner still have to complete the forms? You can do your head. Do they have to? I'm seeing both ways. Yes, a for sale by owner would have to complete this form. It doesn't matter if a broker's in charge or broker's involved or not.
Where do they get the form? I mean, if the form is provided by the REC, so how do they have access to the form?
If the buyer's working with an if the agent's working with a buyer, don't I have a duty to provide that to the seller so they can complete it for my buyer? Absolutely. What if they're going outside of brokers? People buy and sell homes every day without the assistance of an agent.
Right.
So now we have an attorney involved, and the attorney should be making sure, because the contract says that the buyer should get this form. So FSBOs are not exempt from completing this form. And that's where we say we have a duty to assist in delivery to the buyer. So even though I'm a buyer's agent, I still need to get this form to the FSBO and say, you need to complete this. Okay. We have to keep the signed forms, because what do we document? Everything. So we're going to have the signed form when the seller signs it, of course, and then when the offer is presented, we will have the buyer sign on the disclosure. And then we always have that duty to disclose material facts. Again, it doesn't matter how the seller completes the form. They say no representation on the whole thing, that's their right, but that doesn't negate us for completing the form. So let me ask you guys something. Can I make anybody do anything? Can I force them to complete this form? I mean, I can ask, I can try, I can tell them why they should do it, applicable by law, da 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 da. But bottom line, I can't make them do it. And if your seller refuses to do it, all we can do is document our efforts, right? I emailed it to him 4 times. I had a phone conversation about it. I followed it up with an email. I sent him a text and said, have you done that yet? I can't make them, but I can show, if it goes down, I can show that I tried. I tried really, really hard to get them to complete this form. So the listing, yeah.
And if both parties still want to proceed with the sale, they can.
That's right. The buyer doesn't have to terminate. They have the option to terminate because they didn't receive it.
Okay.
So that's right. That's right. If the buyer doesn't terminate after those 3 days, we proceed. And that's a great point, Nabila. Sellers, they can't lie, right? But they also should not encourage the buyer to not inspect, not investigate, not get the facts about the property, right? So they can't lie, and they can't say, oh, don't worry about it, it's fine, you don't need an inspection. The buyer has the right to have the property inspected, always. Listing agent duties, we need to provide the seller with a form to complete, if applicable. Again, we'll look at the exceptions in just a second. So we're going to provide the seller to complete. Guys, let's go back to our FSBO. I know agents that that's their niche. They go after for sale by owners. And one tool that they have when they go calling or knocking on the door is the RPODs. Did you know you needed to complete this? And some FSBOs will say, oh gosh, no, I didn't know that. Maybe I need an agent after all. But that's in some cases is their ticket in the door. So we have the forms available. We can provide the seller with the forms to complete. We advise the sellers of their rights and duties under the act. Again, we'll see those in just a second. And we need to let the seller know, look, if you don't do it, this could be an out for the buyer. So we just need to explain the consequences, the obligation to complete it, the consequences for not completing it. Can I complete it for the seller? See, a nose. I would agree with that. I can assist and I can help, but I can't sit down and do it for them. I've never lived in the house. I've probably only seen this thing like once, and it might have been for, you know, half hour or an hour or something. You guys with me? So I can't complete, I can help, I can answer questions. I had a seller once, bless her heart, she was probably mid-80s, and she didn't have a computer or an email, so we were going old school, wet signatures. And we were hanging out at her kitchen table getting all of our listing paperwork signed. And I whipped out this residential property disclosure. And if you've seen it, you'll see it in a second. But you know, the font's like teeny tiny, you know. And she looked at me and she said, Julie, I can't see that. And I'm like, fair enough. I can barely see it myself, you know. So I just read to her. We just went through the form item by item and read to her so she could complete it. But she needed my help, or a magnifying glass. To help her see all those little words to complete the form. So we can assist. I don't want you guys to think that we're hands off. We can assist, but we can't do it for them. The buyer's agent then has the duty to explain the buyer's rights to cancel should the seller not provide. Again, it's important that we understand, that the buyer particularly understands, that they're not saying, and I like the way this form is complete, right? Caveat emptor, seller doesn't have to disclose. All the buyer is signing is acknowledging receipt. So let's go out. If you guys have this. You good? Okay. So let's go out. Let's look at a few things. And first off, let's look in our manual. We're in the 203 material. No, where are we? 303. And in the 303, we are going to look at some exceptions. This topic is actually in the chapter 8, which in 301, you'll spend more time in chapter 8. It's one of our agency. But the reason we're in chapter 8 here is because we're talking about working with sellers, and particularly their duties and obligations to the residential property disclosure. So if we come down just a little bit further. What I want to show, section talks about the act and the disclosure forms. It tells us the law applies to FSBOs even without a broker. Again, if no agents are involved, then we're going to have an attorney involved anyway. So the for sale by owner is not exempt. And then we have those that are exempt, first off, by the RPODs, Residential Property and Owners Association Disclosure Statement. The biggest reason that this form is exempt is going to be new construction. The R-Pose is not required for new construction. Why? Because it's never been lived in. Nobody's lived in it's hard to attest to the components of a property when it's not been lived in. Does that make sense? The builder's probably been very involved in it, but did he ever stay the night? Did he ever move in? Probably not. So new construction is probably the biggest reason. If it is new construction, I think didn't we look at the owners association disclosure statement? Did we look at that already? I think we did. So that form kind of addresses the HOA information if it is new construction and the R-Pose isn't required. By the way, if you're in the book, I'm on page 181, if you're in the hard book. Transfers by lease with option to purchase where the leasee occupies or intends to occupy is going to be exempt. Any transfer from the state, again, they never lived there. The government never lived in the house, so they're not going to be able to attest to it. Any transfer from one or more coworkers to another coworker, any transfer from one spouse to another. Maybe if you get married and you transfer from me to us, or maybe if you get divorced and you transfer from us to me, right? So anytime a divorce or marriage situation wouldn't be required. Pursuant to a court order. So if the judge takes the property for any reason, the R-Pose wouldn't be required. Any connection with a foreclosure. Transfer by a fiduciary, so an executor, a guardian, a trustee. Think an executor of a will. Usually for those, I see these complete, but they almost always say no representation because the executor, again, probably never lived there. It's hard to say yes or no to something when you don't live there and you don't know. Connection for owner's failure to pay taxes. Transfer where the parties agree that the owner not to provide. Again, that, once the buyer gets past their 3 days, that option to cancel is out. So the seller shouldn't try to persuade the buyer into believing that they don't have to provide that. That shouldn't be a conversation. Lot sales are exempt from the R-Pose because you don't have a property on it. You don't have a property to disclose any information. So lot sales would be exempt. And then when we look at our MOG, mineral and oil and gas rights, the transfers that exempt are the same, except in a MOG, new construction, the MOG is required. So with new construction, we're going to have a MOG because there's still land, right? And that's what the MOG is telling us, whether or not they have severed the land. Lease with the option is not going to be an exclusion for the MOG. And then transfers between parties that are not doing the R-Pose. So that's back to our new construction with the Owners Association disclosure statement. These list of exemptions, by the way, are also, we can find them in your real estate manual, of course. But you can also find them in the guidelines to completing the offer to purchase and contract. So most of our standard forms have guidelines to complete to assist us in filling out the forms. So you could find that if you're not sure if your seller or your buyer would be exempt from it. Questions on the exemptions when it wouldn't be required? So let's go now under our Campbell folder and Learn Test Pass. Let's look first at the Residential Property and Owner Association disclosure statement. And it starts with instructions to property owners. If you're the listing agent, you're working with the seller, they want to know how to complete this. There's your words. There's what you can do to help explain it to them. So it tells us the act requires owners of residential real estate to furnish buyers with a copy of the statement. This form is the only one approved for this purpose. The disclosure statement must be furnished in connection with the sale, exchange, option, sale under a lease with option to purchase where the tenant does not occupy. Disclosure statement is not required for some transactions. including the first sale of the dwelling that has never been inhabited, and transactions of property made pursuant to a lease with an option where the leasee intends. For complete list, they send you the general statute, but I would think it'd be easier to look it up in your book or go to the guidelines to complete, but you can go look at the actual act. Then it tells the seller you have to respond to each of the questions on the following pages by filling in the requested information or putting a check in the box. In responding to the questions, you are only obligated to disclose information about which you have actual knowledge. If you check yes, you have to explain your answer and either describe any problem or attach a report from an attorney, engineer, pest control, etc. If you attach a report, you will not be liable for any inaccurate or incomplete information as long as you were not grossly negligent in obtaining or transmitting the information. So in other words, you can't be responsible for the home inspection report or the pest inspection report, or the seller can't be responsible. The seller's is simply providing it for an FYI. If you check no, you're stating that you have no actual knowledge of the problem. If you check no and you know there is a problem, you may be liable for making intentional misstatement. So if the seller's saying no, they better know that there's not a problem. That's what we mean. They can't lie, because the buyer possibly could come after them if they found out later that they did lie. If you check no representation, you are choosing not to disclose the conditions or characteristics of the property, even if you have actual knowledge or should have known. If you check yes or no and something happens to the property to make your statement incorrect or inaccurate, you must give the buyer a corrected disclosure statement or correct the problem. Let's talk about this for a second. If anything changes in the condition of the property once we list it, we need to work with our sellers to do an updated disclosure. So let's say, for example, you list the property and the roof wasn't leaking. And then next week something happens and now the roof leaks. We need to get with our sellers to update that disclosure form. Does that make sense to everybody? I need to see everybody's head nod, please, and I'll tell you why. If you guys pay attention, that disciplinary action in the real estate commission e-bulletin, I have seen this more in the last 6-8 months than I've seen in the last 20 years. So agents are getting themselves in trouble with the real estate commission for not assisting their sellers in updating the forms when any of this information changes. Is everybody good with that?
What if, Julie, so I had something similar to this happen. I had some buyers that were buying a house and they had checked on the disclosure. The sellers had checked that there was no polybutylene pipes.
Mm-hmm.
And then when we went to actually the showing, it was obvious that the pipes were polybutylene. And so I took pictures of them and I notified the listing agent that, hey, I know that this is what the property disclosure says, that they didn't check no representation. They had actually checked, that the pipes were plastic or something. And I let her know and I sent her the picture, but they would not update the property disclosure. They should have, right?
Yes, absolutely. Because I mean, sellers don't know their house, right? So maybe they genuinely thought that they were plastic or whatever. And then, I mean, honestly, yes, the seller should have done that. Maybe the listing agent tried to get the seller to update it. We don't know the whole side of that story. You know what I'm saying? So maybe the listing agent tried and the seller said, I already did it once, I'm not doing it again. I mean, we don't know, but the fact is that you have documentation that and I'm sure you discussed this with your buyer as well. You said, I know what they said here, but look, we can see right here that this is what it is. So, should they be encouraged to? Yes, but that goes back to, I can't make them do anything. So what we hopefully have is your documentation. Did they buy that house?
They did, but they got every inspection under the sun.
And I'm sure the home inspector confirmed that they were the polybutylene pipes. So they knew going into it. They had to discover it themselves, but they knew going into it.
And I made sure to put it in writing before I submitted their offer. I put it in writing to them in an email that just to remind you from the showing, the
Even though
property
this is
disclosure is
that,
wrong. This
yeah.
is, yeah.
Yeah, so this is where it says, back up to here. If you check no and you know there is a problem, you may be liable for making an intentional misrepresentation. So if that buyer was to take that seller to court, the judge is going to say, well, didn't you get a home inspection? Didn't you, you know what I'm saying? So would the seller be liable in that case? It's awfully hard for the buyer to go successfully go after the seller. I mean, we know we can sue anybody for anything, right? But it would be awfully, I would think it would be awfully hard in that case because their home inspections, you help them reveal their home inspections. So the judge is going to say, okay, you still bought knowing what you knew. Why are we here? If this was a big of a deal, why didn't you address it? So I think you did absolute everything right, Chastity. And like I said, we'll never know if the listing agent had a conversation with the sellers or not. We'll never know that end of it. But if you are the listing agent and you get that call, from Chastity that says this form isn't right, here are pictures, I would highly recommend you addressing it with your sellers and encouraging them to change that form. So good for you. Let's see. If you are assisted in the sale of your property by a broker, you are still responsible for completing and delivering the disclosure statement to the buyers. The broker must disclose any material facts about the property which they reasonably know, regardless of your response to the disclosure statement. So again, here's, hopefully we told the seller we have this duty to disclose like back in the day when we were at the listing appointment, right? So now here we are getting the paperwork signed. And so this is just reiterating to the seller that it doesn't matter how you complete this form, we still have that duty to disclose material facts. And then the last note to the property owner, you must give the disclosure statement to the buyer no later than the time the buyer makes an offer to purchase. If you do not, the buyer can cancel any resulting contract. We're going to see the note to buyer in just a second. You should give the buyer a copy of the statement containing your signature and keep a copy signed by the buyer for your records. So again, listing agents, if you're working with sellers, let's have a conversation about this. Let's discuss it. It's right here for us to help us bullet points and everything. Then we have a note to the buyer. If the owner does not give you the RPODs, by the time you make an offer to purchase, you may, under certain conditions, cancel any resulting contract without penalty to you as the buyer, which means you will get your deposits and fees back, your earnest money and your due diligence. To cancel the contract, you must personally deliver or mail written notice to your decision to cancel to the owner or the owner's agent within 3 calendar days following receipt, or 3 calendar days following the date of the contract, whichever occurs first. In no event does the act permit you to cancel a contract after settlement, or in the case, or after you've occupied the property, whichever occurs first. So we've seen this. We have this in our manual. We have the buyer's right to cancel. We have it in the guidelines to complete, and we also have it right here on the form itself. Fill in the property address and the owner's name, and then the owners sign acknowledging they have examined the statement before signing and that all information is true and correct as of the date signed. So they're saying, yes, this is right. And then buyer, before we present the offer, acknowledges receipt of a copy of the statement, that they have examined it before signing, that they understand this is not a warranty by owners or owners' agents, that is not a substitute for any inspections they may wish to obtain, and that the representations are made by the owners and not the owner's agents or subagents. Buyers are strongly encouraged to obtain their own inspections from a licensed home inspector. Words in plural include the singular. So regardless of how the seller completes this form, the buyer should be encouraged to have their own inspections and investigations. This form does not negate a home inspection. Even if the seller says, yes, everything is wrong with this house, we appreciate your honesty, but the home inspector, the buyer should still have a home inspector come in and put their eyes on it as well. Then we put the property address again. The following questions address the characteristics and conditions of the property identified above about which the owner has actual knowledge. I don't know what I don't know, right? So if I have no evidence that the roof is leaking, there's no water stains on the ceiling, there's no moldy smell in the attic, right? If I have no evidence, then I can't disclose it. Now, big rain may come through tomorrow that now I may know, but the seller can only disclose what they know. Anything referring to a dwelling, it is intended to refer to the dwelling unit or units if more than one to be conveyed. The term dwelling unit refers to any structure intended for human habitation. And then we can see, and I'll let you guys look at this if you haven't. We're going to go through a whole laundry list of questions and gathering information about the property. What year was it constructed? Explain if necessary. Is there any problem with the foundation, fireplace, etc.? What's the exterior type of material? And what year was the roof installed? Is there any leaking with the roof? Any dampness in the basement? Any malfunction electrical systems, and so on and so on and so on. And as you can see, as we've said, the seller's three choices are, for the most part, yes, no, or no representation. How do you guys interpret when the whole form says no representation? How do you tend to interpret that? The sellers come in and sometimes they even just draw a line down it and say no representation. What does that mean to you?
The seller doesn't want to be liable for anything.
The seller doesn't want to be liable for anything, so their easy out is to say no representation.
Yeah,
Kind of has a flag go up, doesn't it?
as is.
As is.
Well, flag in a sense that, like, yeah, you're buying, you know, you're it's buyers beware. Like, the seller's not giving you any information, so it's
They don't
your
have to.
responsibility to
Right.
discover. That's what I would think.
I tend to think that too. Anybody else think kind of about the same? New agents typically, well, seasoned agents too, but agents sometimes see this and think, oh no, it's a shady seller. They're trying to hide everything. They don't want to disclose. They're not gonna, and they're gonna do. Maybe they're a shady seller, maybe they're not, right? Maybe they're exercising their right not to disclose under caveat emptor. Maybe they've never lived in the house and they don't know. What if it's been a rental for the last 30 years? Or what if it is that as an estate, right? So it might be that no representation is their honest answer. Okay, they may not know. And so no representation is what they're comfortable answering because they don't know yes or no. So
Well,
I just,
and then it's kind of like, even if you say that, no, you don't know a roof leaks, and you put no, even though you're trying to be honest, it can almost backfire too.
because
So-
what if the roof starts leaking tomorrow? You
Right.
say, no, the roof doesn't leak, and then we're getting rain tomorrow, I hope.
Oh, yeah,
You know,
true.
so the rain comes through tomorrow. There was a roof leak that happened last week. I don't know how, but it did. Yeah. So the seller is kind of making themselves a little liable for saying yes or no, right? I mean, honestly, guys, I get more nervous about the seller that says no for everything. Really? You're telling me there's absolutely nothing? That's when my flag goes up. You guys with me? Because again, I know there's no such thing as a perfect
Exactly.
home. So I tend to have a flag go up more for the no than I do the no representation.
Mm. Yeah.
I agree.
I just don't want
Me
you
too.
guys to get excited or get your buyers excited when the seller says no representation. Okay, it is what it is. Maybe the seller's just lazy and they don't feel like doing this form and they see they have the option to say no representation, right? There could be a cajillion reasons why they say no representation. What we need to explain to our buyers is that's the seller's right. Whether the buyer likes it or not, That's the seller's right under caveat emptor. And no matter how the seller completes this form, the buyer should be encouraged to have, if they say no for everything, please don't look at your buyer and say, this house is fine. The seller didn't represent anything, so you don't need a home inspection. They should always be encouraged to have a home inspection. Let's see. Here's what Chastity was just talking about. The dwelling's water pipes are made of what material? And you're saying they check plastic, and you saw it was polybutylene. So, again, sometimes, if you guys are active, you've probably met these sellers already. You don't have to go far to meet somebody that doesn't know. They don't know what pipes they have. They never, ever been to the crawl space. So they don't know what they are. So maybe they're saying no representation just because they don't have that actual knowledge. They're not a plumber or have any experience whatsoever with plumber, and they don't know what their pipes are made of.
Can we, what is the butane again?
We're actually going to talk about that in just a bit. So, yep, hang on to that. That's a good question, because that is a funny word, isn't it? So we'll talk about that in just a bit. Let's see. What's the sewage disposal? If it is on a septic tank, do you know how many bedrooms are allowed? Remember, we can only, if it's on an on-site septic, we can only advertise the number of bedrooms allowed in the septic permit. So if you're getting ready to list a property and it's on an on-site septic system, what should you ask the seller for? The permit. We need to put our eyes on that permit, don't we? And if they don't have it, have them get on the phone with the county, have them get that started, because you know what a good buyer's agent's going to ask for? The septic permit. So have your sellers, maybe the county will talk to you, but I think for the most part, the county's going to want to talk to the seller. So the two of you can start working together, though, and getting that information. One, so you know how to properly advertise the number of bedrooms, but two, you're prepared when the buyer's agent says, don't you have a permit we can look at? Let's see. So we go through this whole exercise together, and then it says, well, what the seller goes through it, we assist. And then it says, if you answer yes to any of the questions listed above, please explain, and then attach additional sheets if necessary. So anytime you see yes checked over here, there should be an explanation. There should be further information. And then the rest of the RPODs is if there's an HOA involved. So if there's not an HOA, then, we may not need to complete this last part, right? But if there is an HOA, then we need to provide that information to the buyer as well. And again, this last piece is pretty much what that owner's association disclosure statement looked like. Because remember, we use the owner's association disclosure statement when the RPODs isn't required. And when is that not required? New construction. So if you're working with a builder, you're not going to see this form. But if they're buying in an HOA, or they're building in an HOA, then you're going to want to see the owner's association disclosure statement. Questions about the RPODs? Everybody good with me calling it RPODs? Here's the official Residential Property and Owner Association disclosure statement. The other disclosure form is the MOG, or here it is, Mineral and Oil and Gas Rights Mandatory Disclosure Statement. Again, it starts with instruction to property owners. The Act requires owners of certain residential real estate to furnish the MOG. This form is the only one approved for this purpose. The disclosure, statement is not required for some transactions. For a complete list, we can either go to the general statute, or you can go to your manual or the guidelines. For a complete list of exemptions, see this general statute. Here's some of the things that might be exempt. You must respond to each by placing a check in the appropriate box. And then we have the disclosure. Mineral rights and or oil and gas rights can be severed from the title to real property by conveyance of the mineral rights and or oil and gas rights from the owner, or by reservation of those rights by the owner. If the rights are or will be severed from the property, the owner of those rights may have perpetual right to drill, mine, explore, and remove any of the subsurface minerals, resources, gases, oils on or from the property, either directly from the surface or from a nearby location. With regard to the severance of these minerals, oils, and gases, seller makes the following disclosures. And when we're looking at this, I think this one's helpful to divide this in half. So let's look at the top half first. The top half addresses mineral rights. And this first little section, it starts with mineral rights were severed from the property by a previous owner. The seller can say yes, no, or no representation. They may or may not know if the previous owner severed the rights. We'd like to think that they should, but they may or may not know. Remember, this wasn't really a big deal until 2015. So it might have been they bought prior to then and they didn't know. They may not know. And then we ask if the seller has severed the mineral rights or if the seller intends to sever the mineral rights. But look at this. Their only options are to say yes or no. The seller can't say no representation. So they have to disclose either they have or they intend to sever. And then we go through that same little exercise with oil and gas. They were severed from the previous owner. Yes, no, no representation. Seller has intended or seller intends. Questions on that? Comments? I think we learned yesterday that if you're going to sever those rights, there's a lot of legalities involved. So if you're working with a seller and they say, yeah, I have those rights. Okay, what do you have from the attorney? What's your documentation? If your buyer wants to buy a property that the rights have been severed, we need to advise them to talk to their attorney. It's a whole separate body of law, and we are in absolutely no way equipped to address that. Sellers don't understand this form. Please don't send it to the seller and just say, fill this in and send it back to me. We need to make sure we help them explain this, because I learned that lesson the hard way. I sent that to a seller and they came back and no, that's not true. They came back and said yes to everything. And my first thought was, I didn't do a good job of explaining this form. So we needed to go back, have a conversation. I had to have them redo it. And now I explain it to my sellers. What are you filling out? Here's our note to purchaser. Again, going over the cancel, the right that the buyer has to cancel if the form's not provided to them. Again, they can't cancel because they don't like how it's complete. They can only cancel because they don't have it in their possession. Owner signs, acknowledging they have examined before signing that all information is true and correct. And then the purchaser acknowledges receipt of the disclosure statement, that they have examined it before signing. They understand this is not a warranty by owner or owner's agent, and that the representations are made by the owner and not the owner's agent or subagent. So far, this is still a one-page form. We're like one edit away from this thing becoming two. So who knows if and when, that can happen. We have very few one-page forms left anymore. So that's why I bring that up. Questions on this one?
I do, being that this is a new form to me.
Please.
Now I have more time to think about all this. So the land, so when a buyer is purchasing a home, so they're purchasing the building and the land, which the building sits, the structure sits on. However, the land may have some mineral oil and gas. I I don't know, gas, whatever,
Mhm.
properties, right?
Mhm.
That could have been sold to somebody else.
Mhm. Yep.
And so the land that really?
Mhm. In
Okay.
North Carolina, you can sever your subsurface rights. So you can sell or lease the rights to somebody else to either come and purchase or lease to mine or drill, or maybe not specific to North Carolina, but let's go up north just a little bit and let's talk about like our coal mines in West Virginia. Those coal mines are like miles below the surface, right? I mean, they drop, a little elevator and they go like like miles below the surface. They are probably mining underneath somebody's home. They had to sever those subsurface rights. They had to allow them, because remember, we own, all the air up into infinity, and we own the land down to the center of the earth.
Correct, right.
So you can sever those rights, absolutely. And that's what we have to disclose, if it's been done or if it's going to intend to be done. Coming soon to North Carolina. Y'all ready for this? It's going to happen, I bet you, in our lifetime. Fracking. And one day we're going to deal with fracking, and we're going to deal with property owners that have severed those gas rights so they can come in and frack. I don't know when it's going to happen, but I'd be willing to bet you and I get to deal with it at some point in our real estate career. Anybody
Hey,
dealing with it yet? Some of you down east, are you dealing with fracking yet? Not yet.
What is that again?
Fracking,
Yes.
extracting the gases from the.
Oh, okay, yeah.
There's been some articles in the Winston-Salem Journal the last several months. There's a property, it's either in Clemens or Yadkin County somewhere, where neighbors have been complaining because a company brought in a bunch of equipment and was drilling, and basically, I guess one of their neighbors, they had a bunch of land and they did this. And so a company brought in some equipment and they've been drilling, and neighbors are raising Cain, and there's been articles about it in the paper.
And what can we do about it? Not much, right? Because they either purchased or leased. I'm presuming they either purchased or leased those rights.
And the new buyer, the new owner of the property, if it's leased, okay, well, yeah, I'm sorry. So the new owner of the property doesn't have any rights, they can't get them back?
I'm not an attorney, so I'm not going to answer that. And that's the key to know about this form. If there's anything checked yes, then we need to get an attorney involved, because that's what we're saying. This is a whole separate body of law that we are in no way expected to be involved with. I mean, we can't be involved in law anyway, right? But we're really, because it's a whole separate issue. So if they have severed, or if they intend to sever, may that be for sale or for lease, then an attorney needs to get involved right now. Anything else about our PODs or MOG?
Yeah, they don't do a good job of explaining this. I'm definitely going back and looking at my transactions, because I had never seen this before, and I had no idea. Even as an agent, I was like, "What the heck is this?" And I guess because one of them, the attorney sent to me, and the agent sent it at the last minute. And I'm just like, I know I'm going to look into all of this. I'm going back to my transactions and my emails. And I'm like, oil and gas, and like, what does that? I'm telling you, maybe because I was a realtor in an urban area, like we don't even have that much land. The only thing we knew, was focused on was the air We
Right.
discussed that.
Because you got air traffic, air
Yeah.
flight traffic, so
Right.
that absolutely affects our air rights.
A lot of
Yeah.
condos,
Yep.
things like
Yeah.
that. But this right here, I just didn't even, yeah, anyhow. So I'm,
Yep.
I'm getting stuck thinking about my
Good.
own
Good.
transaction.
I'm glad we had this conversation because yeah, I mean, if you're in North Carolina, that this is and like I said, I mean, when you look in the MLS, 98% of the time, and I just made that number up, but a good chunk of the time, these are already there. So this really is a conversation about completing them and it's going to be on the listing side of it. The buyer's responsibility is just to sign acknowledging receipt. So if you're on the listing side, then you definitely want to, be having these conversations with your seller and have them complete it.
Very interesting.
Anything else? Our codes or MOG? Okay,
So who paid taxes on the land?
the owner.
So wait. The
Is
owner
it the seller or is it, yeah, I mean, yeah, it's still taxes, still
you
property
sever your
taxes.
right. So they
But
sever
you're
their
not severing the land, you're just severing your right to the minerals and gases in the land. If you had the rights to my land and I went out back after class tonight and I started digging and lo and behold, I struck oil. Even though I found it, it's on my land, you have the rights to those oil. So you're going to bring your truck and you're going to take all my oil and I'm just going to stand here and cry and watch it go, watch all that money go away with you. Because I gave you those rights to that oil. You don't own my land.
Right. Okay, you're right.
But it's your oil.
Right. Okay.
And I'm going to say, why did I give that to her? Feel like Jed Clampett or something, or you would. All right, let's take 10. I got 1014, just turned 1014. So let's come, or 1004. Here we go. Come back. There we go at 1014. All right. Questions on the Act, Residential Property Disclosure Act? Our forms, our obligations with the forms. Again, our duty to discover and disclose material facts, regardless of who we represent. So this is worth saying, you know, louder one time for the guy in the back, right? We always have a duty to disclose material facts. I don't care if you're talking to a customer or client. I don't care who you are. Are you acting as the listing agent, the buyer's agent, seller sub-agent, dual agent, designated dual agent? We always have a duty to disclose material facts. So with that being said, let's have a conversation about material facts. The definition of material facts is a very broad. I mean, the broad definition just says any fact that a purchaser would consider relevant when trying to make a decision. Well, gee, what does that mean, right? So the commission has tried to help us better understand that broad definition. And they've given us things that are specifically material facts. And those are, we're going to break those down. So the question then is, what are considered material facts? We're going to go again through each of them. And the first thing that's considered a material fact is facts about the property itself. Could you guys give me some examples about what would be considered a material fact about the property itself?
Leaky roof.
Leaky roof,
Flood zone.
maybe. What else about the property, the actual structure?
Radon gas.
Radon, high radon levels, yep.
Like foundation or structural issues.
Absolutely. Absolutely. Those structural issues aren't cheap to remedy, are they? So that could absolutely affect somebody's decision. So there is no, you know, clear cut. Some examples could be that leaking roof. Is there electrical issues? I don't know the cost of rewiring the whole house, but if there's electrical issues, foundation problems, HVAC not working, riddled with termites, right? Leaky basement. Some other things that could be considered facts about the property itself that we talked about earlier, manufactured home or modular home would be something that we would need to disclose. Particularly with the manufactured home, is it personal property or real property? Has it been, bless you, has it been, you know, detached from the wheels and the hitch? Has it had the title removed? Has it converted from personal property to real property? With a modular home, if we know that, we need to disclose it. Here's Chastity's polybutylene pipes. What makes these a problem? For lack of a better word, they're cheap. And if they haven't leaked yet, they probably will. They become a material fact once they've leaked. You know, I would give somebody a heads up if they haven't leaked yet. You hear me say yet, right? Because the joke is, the saying is, if they haven't leaked yet, they will. But understand, for us, they're not a material fact until they leak. And once they leak, they're always a material fact, even if they've been repaired. Something else that will always be a material fact is synthetic stucco, also known as ephes. Stucco is a type of siding. I don't know how well you can see from that picture, but you see how it's kind of like concrete looking? Like if you were to touch it, it would be rough. Synthetic stucco then is fake stucco, right? And the problem with fake stucco is it allows for moisture to get behind it. We know moisture in a house is not good. So it might be that there's moisture trap back there, mold, wood rot. Even if the home, the exterior has been reclad. So we found it was synthetic, it's been fixed, it will always remain a material fact on the property. Questions on that? You can tell, one way you can tell if it's fake or not, if it's the real deal, it's concrete. So if you go outside and knock on your sidewalk, it's pretty solid, right? If you go outside and knock on your sidewalk and it's hollow, then that's going to be kind of a fake kind of sound. And concrete shouldn't sound hollow when you knock on it. It should be. So if the seller says, I don't know, then just go outside and knock on the side of their house and see, see what they say. But again, once it's been discovered, if it's ever been clad in synthetic stucco, it will always remain a material fact, even if it's been completely replaced. Something else that will always be a material fact in North Carolina, if the home was a previous site of a meth house, a meth home. And what we mean by this is you shouldn't have to question, would that be a material fact or not? I'm telling you it is. Once we discover it's been a meth home, then we always have that duty to disclose. How do we find out? Doesn't matter. Once we find out, we know. Sabrina mentioned radon. Any radon levels higher than what? What's the magic pick you carry?
4.0.
4.0. So anything higher than 4.0 picocuries is deemed undesirable by the EPA. So when we get that radon test at 4.1, the seller says, I'm not going to fix it. Buyer says, I'm not going to buy. They terminate. We go back on the market. We, the listing agent, now have a material fact on our hand, don't we? Sometimes it's seller for the better for the seller to fix it, because something like radon doesn't go away. If you don't deal with it this buyer, you're going to have to deal with it the next buyer. So sometimes, although I still can't make them do it, but sometimes it's worth the seller to fix a problem. But again, once we learn it's over 4.0 picocuries, it's a material fact that we disclose. Any unpermitted improvements or space. Remember, we can count unpermitted space in our total living square foot. We can count it. We can advertise it, but we have to disclose that it's unpermitted. We have to disclose the finished basement is unpermitted, or the addition in the back of the home is unpermitted. That's what we disclose, is that it's unpermitted. It was completed. The buyer's homeowner's insurance company may care about this. Let's say you build a room on the back of your house without permits, and then later that house catches on fire, and the fire inspectors determine that it started due to faulty electrical in that room in the back of the house that you added and didn't have the permits. The insurance company probably isn't going to touch that. The insurance company is going to say, had you had the permits done, the electrical wouldn't be faulty and we wouldn't be here. That's why a buyer needs to know about it. It could affect what is and is not insured in their property. We should disclose any grave sites on the property. Maybe they're just relocated tombstones, maybe they're not. We can dig a little deeper, maybe with the history archive of the city, for example. I had a girlfriend a couple years ago. She was at her house. She was in the back, digging up a part of her back of her home, right along the back edge of the wall of the home. And now she's going to put a flower garden in. Lo and behold, she unearthed the tombstone. She called me freaking out a little bit. She was like, what do I do? I said, don't move it first. Let's just leave it there for just a second. She investigated it. She started with the library and the history research department, and she investigated it. And they told her that back in the day, because her house was built in like the 30s or 40s, something like that. So back in the day when families moved, sometimes they would grab the gravestone to take with them. So there's no guarantee that there's an actual grave site because it was butted up to the house. You guys know what I'm saying? So if it was out in the yard somewhere, then that might be a concern, but it was actually butted out. So they felt that it was just relocated when the family moved. Isn't that interesting? She was a little freaked out for a minute. I won't lie. I guess I kind of would be too if I found a gravesite in my yard. Partial destruction of the property. Again, if we rebuild, it's never the same, is it? So if we have to rebuild something like that, it would be a material fact that we might want to disclose. I think sometimes it helps sellers and agents, for that matter, to kind of put yourself in buyer's shoes. If you were buying a house, would this information be important? If you're not sure if it's a material fact, I would tend to err on the side of disclose rather than not disclose. But I think if you ask yourself, if I were a buyer, would I consider this important? And if so, I had an agent in my office not too long ago, and she listed her neighbor's property, and they had a problem with ants, and she knew they had a problem with ants. And she told the buyer there was a problem with ants, thank God, because it wasn't after the buyer bought that they discovered like the nests that were in her yard and the destruction and the kind that like ortho was out, I don't know how many times. They bought knowing there was an issue. I don't think they knew the extent of the issue, but they bought knowing there was an issue. And she said, I didn't know if I should have disclosed that or not, but I'm glad I did, because it was her neighbors. So if these buyers bought and then moved in and then found all these ants, they're going to come knocking on her front door and say, what's up? So she said, I didn't know if that was something I should have disclosed or not, but I did. What do y'all think? Did she do good by disclosing that? I would say so. I mean, ortho was out like 3 or 4 times. It costs them every time to pull in the driveway. So how much money are they putting in to take nests, plural? She said it was bad ant infestation. So what are your thoughts? Like I said, I tend to err on the side of disclose, err on the side of caution. Do we have risk takers out there? No. Another category of material facts would be facts relating directly to the property. Maybe not the structure itself, but it somehow revolves around the property. Justin, this is where I put flood zone. I absolutely think if it's in a flood zone, we need to disclose that, absolutely. But I think be more related to the property, because it may not be, the flood area may not be at the structure itself. It may be like at the back part of the lot. Other examples of anything relating directly to the property would be a proposed zoning amendment on the table. You guys ever drive around and see a zoning sign? It's either a white sign with a red Z or a red sign with a white Z. That's telling you that where there's a public meeting scheduled and they may or may not be considering changing the zoning. If you live in that area or if you market that area, why not go to the zoning meeting? I think there for a while most of them obviously were on Zoom, but maybe they're back in person now. I'm going to say every city's different. But if you want to know more about what that's about, then that's what that sign is doing, is inviting you to that public hearing. Any permitting regulations, flood zones, we said, obviously the need for flood insurance, whether or not the property is insurable or not. Remember, not all people, not all properties are easily insurable. So if the property, for example, has had lots of claims The deductible, the premium may be a little bit higher because there's so many issues with the property. Any covenants, we need to disclose those if you're in an HOA or subdivision. Plan development. And then future roads. Before you list a property, please go to NCDOT's website. Check it out. Just because the construction crew isn't there yet doesn't mean it's not planned. I mean, sometimes these things are in the plans for years before you and I ever see the crews show up. So go to NCDOT and check it out.
Can you keep stored, can you store cremation remains on a property?
As far as I know,
Like if you wanted
I
to
mean-
put it like in the ground somewhere, like, okay, by a tree or something?
if we know about it, we should disclose that, yeah. But I mean, I don't know why the owner,
That's-
couldn't. I don't know the state rules on, on that, but I know if we know that, it's a grave site, then yeah, we should disclose it. So I'm not sure about cremation or anything.
That's still a material factor, you think? Well, you're not sure. about
If it's, I mean, can you do it legally? I don't know. But if it is there, then we're gonna disclose it.
it. Okay.
I don't know. Some areas have rules about, spreading ashes, you know what I'm saying? So legally, I don't know if you're supposed to do it or not. But what I do know is if they do, we find out, we need to disclose that.
Oh, yeah, that would make sense, so.
Another category of material facts are facts relating directly to the ability of the principal to complete the transaction. This one's a mouthful, isn't it? I think mostly this comes down to money. If the seller's facing foreclosure or bankruptcy, if we find out that the buyer can't get loan approval, we got to disclose that. So buyer's agents, when you find out your buyer's loan is denied, do you have to call the listing agent and tell them? Yes, that's a material fact. Again, I tend to err on the side of disclosure. Even when my buyer's loan approval gets rocky, things start looking like it may not look real good, I contact the listing agent. Sometimes we can save it with another lender. If you have your preferred lender. Mine, I used to say I was going to buy mine a cape because I swear he got me out of many. He put out many fires for me and my clients. If there's any issues with the title, the seller's got to clear those up before they can convey. So if we find any issue, cloud on title, any issues with the title, we need to disclose that. The attorney's going to find them, of course. But if we find something, I mean, maybe the seller tells you this isn't a clear title. What do I do? Well, until we get an attorney, until attorney resolves it, it's a material fact because they may not be able to convey the property. And then the last little category of material facts are matters of special importance to a party. If it's important to my buyer, then it's important to me. So once the buyer shares with me something that's of special importance, something that's of specific importance to them, I now have a material fact on my hands. I need to make sure that their end use is allowed. If the buyer wants to put a fence up, if you're in an HOA, don't look at a fence in a neighbor's yard and say, oh, they have a fence up, so I'm sure the HOA will allow it. You don't know if the HOA allows it or not. The HOA and that homeowner could be in the throes of the legal battle to have that fence removed, or they might be fined X amount every day that fence is up. When you see a fence, you don't know that that's somebody's property line. All you know by looking at a fence is that somebody put a fence there. That's it. That's all you know. You don't know if it's allowed to be there, if that's where it's supposed to go. All you know is that somebody came in and put a fence there. Same thing in subdivision or HOAs with storage buildings, anything like that. Don't look at what the neighbors are doing. Help your buyer get those hands on the covenants and let them see for themselves if they can put a fence up or a storage building. And then if your buyer wants to operate a home business, what if your buyer tells you they want to have a home daycare? Don't I now have a duty to make sure zoning allows that? Don't I now have a duty to make sure that the covenants, if applicable, allow that? Once they share something with me, then I have a material fact in my hands. I have a duty to make sure that the home that they buy, they can put a fence up and open up a home daycare. Questions on that? So if these are things that are material facts in North Carolina, let's talk about some things that are not material facts in North Carolina. And one thing that's not material fact in North Carolina are stigmatized properties. You guys working with buyers, have you been asked yet? Did somebody die in this house? Get prepared for that. You haven't been asked that yet? You will. Don't worry, you will. Walk in the front door. Does somebody die in this house? Some buyers care more than others. When it comes to stigmatized property, we don't have to volunteer the information. However, if we're straight up asked, we can't lie. We have to answer honestly. Maybe your honest answer is, I don't know. I don't know if somebody died in this house or not. Stigmatized property are not a material fact. There is one exception to this rule. Does anybody remember the exception? Making me think this morning.
Can you re-ask the question, please? I'm sorry.
What's the exception, the one exception to this rule? If you're ever asked if the previous occupant had AIDS or HIV, your answer is always, fair housing prohibits me from answering that. I don't care if you know or not. Your answer is always, fair housing prohibits me from answering that. Because those with AIDS or HIV are protected under the handicap disability condition, one of our protected classes. Something else that is not a material fact in North Carolina is the presence of convicted sex offenders nearby. Again, we don't have to volunteer this information, but if we're asked, we can't lie. When it comes to this one, I'm a huge fan of being the source of the source. If your buyers ask, are there any sex offenders nearby? Because they have young kids and they want to know, and I absolutely agree that they should have the right to know. But when they ask, I think the best thing we can do is direct them to the sex offender registry website and let them do their own investigation. Megan's Law requires convicted sex offenders to register. However, I think it's also important we have a conversation with our buyers. The sex offender website only has convicted sex offenders. Anybody that's under trial or hasn't been caught yet is not convicted. That's why this is not, right? I'm not gonna say, there's no sex offenders around. I can tell you there's no convicted offenders, but I can't tell you for sure there are no sex offenders nearby. Does that make sense? And the other thing I think buyers need to understand, well, there may not be a convicted sex offender next door today. That doesn't mean one can't move in tomorrow. So be the source of the source, let them do their own. And bottom line, you guys, let's know where our kids are and who they're with. Please, especially in a new neighborhood. Comments on this one? This one tends to upset us in pre-licensing when we see this for the first time, don't we? We're not trying to be, heartless or anything. We're trying to direct them to the source of the information. But it would be really hard for me to, and not unless I go knocking on all the neighbors' doors and say, you're not a sex offender, are you? It'd be really hard for me to disclose that information. So be the source of the source. Let them do their own inspection on this one.
I agree with that.
I mean, and again, if they have young kids, if they're concerned about it, they can check it like once a month, you know what I'm saying? Even after they move in. So as often as this thing updates, they, you know, they can go in and check it. Have you guys looked in your neighborhood yet? You might be surprised. Something else that's not a material fact, per the North Carolina Real Estate Commission. The North Carolina Real Estate Commission says square footage is not a material fact, but if we do advertise square footage, we are liable for it. We are responsible for it. The Triad MLS requires it. The Real Estate Commission doesn't, but the Triad MLS does. So in the Triad MLS, at the minimum, you have to have the total heated living square foot. Room dimensions are not required. There may be other MLSs, a high country MLS, for example, up in the mountains. This isn't a required field. This is one thing I learned by offering post licensing to agents across the state. We got out of our little Triad bubble with Zoom. And high country MLS, as a matter of fact, the agent I had in my post class that worked up there said, this is weird to us. The fact that you guys disclose material square footage. She said, that's very strange to us. And my first thought was, well, how do you help a buyer buy a house if you don't know the square footage? It's just different marketplace, different practice in different areas. Is everybody good with that? The Real Estate Commission doesn't require it. The MLS might.
Where I come from, we don't require it either. And we actually can't even rely on the information that may be on tax records and things
Oh,
like
no,
that.
no, yeah,
Because,
tax records are bad. We don't rely on that. We don't
yeah,
rely on previous MLS sheets that somebody else's work. So if we're going to disclose it, we either go out and measure it ourselves or we hire somebody with greater experience.
right. But it's not an obligation for us to provide that information. If the buyer wants to know, the buyer could bring someone out, but
Interesting.
the agents will not be liable for providing information if they don't actually know for a fact, not unless
Yep.
they hire.
And we're only liable if we advertise it. So again,
Right.
if you hire somebody to do it, you need to make sure they know what they're doing. Don't hire the 16-year-old up the street, right? Hire an appraiser, hire an agent with more experience, general contractor. You with me? Somebody that has that knowledge, and ask questions before you hire them. Don't just go to Google, because no matter what they say, you are responsible for it. There was a disciplinary action a couple months ago. The agent hired somebody. They provided the report and said, this is the square footage. And the agent said, no, that's not right. I'm going to put in the right amount. Never measured it, never verified, just assumed the person she hired didn't do it right. Guess what? They were. The agent misrepresented the information. The agent got the disciplinary action for it. If you are going to measure your own listings for residential, we need to use what I call the measuring Bible. The official name is North Carolina Real Estate Commission's Residential Square Footage Guidelines. You can get the brochure on their website. Probably under publications. You can do the flat PDF. When you affiliate with a firm, that might be part of your welcome package, is the nice glossy brochure. What do you guys that are active, what do? Do you measure or hire?
I have someone.
You
that-
hire?
Mhm.
It's a task. You're going to be out there for a good while if you do it yourself. Time versus money, right? See if it's worth for you to go or not. What about the rest of you that are active, that have had a listing, I should say? What do you do?
Hire.
You hire? Depends on the house. So if it's a nice, cute little ranch, you could go in and do it real quick. But if it's something with lots of corners, I hear what you're saying. I showed a property once, and it was to friends of mine, but it was an octagon house. It had 8 sides. And my girlfriend said, how would you measure? I said, I wouldn't. I would call somebody. So this got out of the realm of the residential square footage guidelines booklet. We have a general contractor on our team. So he does our measuring for us, which is nice. I like that. So we talked about material facts, and we talked about things that are not material facts. And by the way, let me say one more thing about measuring. If you do measure your own, keep your records, keep your sketches and your scratch marks and everything. Because what do we document? Everything. So if you go measure your house, you got to keep those sketches and documents, because it shows that you did it. Even if you're wrong, it still shows that you did it. So make sure you're documenting everything. So what happens if we mishandle material facts? Well, there's two violations of material facts. We can either misrepresent a material fact, or we can omit a material fact. Misrepresentation is a lie. If you misrepresent something, somehow you have put incorrect information out there. Maybe you meant to, maybe you didn't. That doesn't matter. The point is, you misrepresented a material fact. You got the wrong information. Did you do it verbally? Did you do it in your MLS advertising, email, text, communication with another broker? It doesn't matter. Somehow you got the wrong information out there. If you omit something, then you've kept your mouth shut. You didn't put any information out there. So bottom line, the two violations of material facts are either to lie about it or not disclose it. And we know we never have a reason to lie, but you and I know that we always disclose material facts. So failure to disclose is an omission. Anybody can go down for lying. The broker, the seller, the buyer in some cases, anybody could go down for lying. But only us as brokers can go down for omission. What's caveat emptor say? The seller doesn't have to disclose. So you're not going to get the seller for omission. Does that make sense? You could get the seller for misrepresentation, but only the broker could go down for omission. So let's look at a couple examples, misrepresentation and omission. Tommy is a listing broker and states to a potential buyer that one of his listings has no problems with the roof. Later, the buyer finds out that the roof is leaking. Are you guys there?
Do you see us, Julie?
I do not. You're frozen on my end. Can you guys see me?
We can see you.
Okay.
Yeah, I can see you.
Yep,
And
you're
hear
And
frozen
the
on my
slide.
end.
I see both.
All right. Bear with me. Yeah, you guys are frozen in some funny facial expressions, by the way.
I imagine so.
Me too. I'm in mid-sentence, so isn't that common? All right, you guys hang out just for 1 minute. Just sit tight for 1 minute, okay? Are we back?
We see you.
Okay, all right. Maybe my laptop's tired. It's been working hard this weekend, hasn't it? All right. So, as we were saying, omission is, no, misrepresentation is a lie. Omission is failure to disclose. So you either open your mouth and a lie falls out, or you keep your mouth shut. So I believe where we were. You guys good? Can you see mine? Okay.
Yeah, we got.
Good. So misrepresentation. Tommy is a listing broker and states to potential buyer that one of his listings has no problems with the roof. Later, the buyer finds out that the roof is leaking. So assuming that it had been leaking when he made that statement, Tommy's going to go down for misrepresentation. He was specifically asked a question, does the roof leak? And he flat out lied, the roof doesn't leak. That's a lie. And that's a misrepresentation. We're going to mention willful and negligent in just a second. But the big picture right now, the thing I want you guys to get is a misrepresentation. Whether you meant to or not, you still got the wrong information out there. Okay. Then our omission, Sandra is a provisional broker who takes her first listing. She tours the property with the seller, but is a bit too nervous to ask the seller about the obvious cracks in the foundation wall. The buyer who does not have a home inspection purchases the property and later finds foundation settlement issues. Could Sandra have avoided this had she'd asked the seller some questions like, gee, wow, that's a big scary crack in your foundation wall. Have you ever had anybody look at it? Right? We've got to constantly have red flags go up. We can't ignore issues. And the fact that, and I think this is you don't have to be a provisional broker to be nervous, right? Going through somebody's house and pointing out all their problems of the home can be a little intimidating, right? But guys, that's our job. And especially as the listing agent, when we're working with sellers, it's not just a duty to disclose material facts. It's a duty to discover and disclose. So we need to be alert to those red flags. So when you see something like this, ask questions. Sandra very well could go down for omission because she didn't promote it to the buyer. She didn't advertise it to the buyer. Misrepresentation and omissions can be broken down a little bit further. You could have a willful act or a negligent act. With a willful act, you have actual knowledge. With a negligent act, you don't know, but you could have found out. Asking the right questions, looking at the property. Do you list a home without looking at it? I sure hope not. Negligent acts. If you go down for a negligent act, the Real Estate Commission is going to perform what's known as the reasonable standards test. And what the reasonable standards test says is, would an agent in that area have been able to find out that information? So
I'm sorry.
Did I go away again?
You're breaking up. I'm sorry, I didn't understand.
The reasonable standards test, the commission's going to ask, would an agent in that area have been able to find out? Reasonable standard test. Could you reasonably have found out this information? If all you had to do, you see a crack in the foundation, ask some questions. If you don't ask questions, the commission's going to say, you saw it. Why didn't you ask? You guys with me? They're going to wonder if you could have found out. And that's our negligent act, because that's exactly what we're doing if we don't find out, right? We're acting negligently. We cannot turn a blind eye to issues in the property. And again, guys, I truly think that between seller and agent, this is the biggest conflict. I do feel this is a bigger conflict than our commission, because sellers don't want us to disclose because they think it hurts their selling power. Maybe it does, maybe it doesn't. But you and I have this duty. And again, when working with sellers, it's not just to disclose, it's to discover and disclose. What is that water stain? What is that crack? We got to ask questions. Comments on that? So quickly, and then we'll go to break in just a second, but real quickly to wrap this up, I kind of want to do a mashup. We've talked about misrepresentation and omission, and we've talked about willful or negligent. So let's do a mashup. The big four is what I call them, and just go through these pretty quickly. If the broker lies and they know, that is willful misrepresentation. Misrepresentation is a lie. Willful means with knowledge. So the broker makes an incorrect statement. They know that statement was wrong. That is willful misrepresentation. Broker makes an incorrect statement. That's still a misrepresentation, but now they have no actual knowledge, nor could they have found out. Or no, let me say no actual knowledge, but could have found out. There we go. No actual knowledge, but could have found out. It's still a lie, but they didn't do their duty. They were negligent. So we got our negligent misrepresentation. Broker does not make a disclosure, but they should have, and they know that they should have disclosed. There's our willful omission. They purposely kept their mouth shut. And then the broker makes no disclosure, but should have, and they're unaware of the issue, or negligent omission. Again, the commission's going to ask, could you have found out? Could you have asked questions and find out? I think when it comes to our omissions, particularly, this is not a situation of don't ask, don't tell. Okay. Once you know about something, you disclose it. You don't have to wait for the buyer to ask. So let's say you know there's termite damage. I don't know how you know, but you know there's termite damage. Those suckers can do some damage to the property, can't they? Especially when they get in the structure and in the main frame of the home, they can do some damage. Would this be a material fact? Oh my goodness, yes. Would a buyer consider this important? You bet. So let's say you know this. You had a conversation with the seller about it, when it started, what they've done to try to fix it, everything. You have an interested buyer. Your defense can't be, but they never asked specifically about termites. That's where we have that duty to disclose, whether they ask or not. Everybody good with that? Buyers like to, I don't know why, but when I do, I've noticed two questions when I do an open house. I almost always get the same two questions. Is the refrigerator going to stay? So I always ask my sellers, are you gonna leave the fridge? Because I know I'm going to get asked. And why are they selling? Can I disclose why my seller's selling without their written permission? No, I can't. So whether or not I share with that at an open house or not depends on if I've gotten my seller's permission to sell it. But I really think what buyers are looking for when they ask that is, oh, because of the termite infestation, or, you know, the crack in the foundation. I think they want me to stand there and say, there's a problem with the house and that's why they're selling. Maybe there is, maybe there isn't. Maybe my seller will disclose, maybe they won't. How I answer that question at the open house is completely dependent on whether or not I have my seller's permission. So you know what? You know you're going to get asked. Go ahead and ask your seller. And if they say no, that's none of their business, soften that up a bit, right? My buyers chose not to disclose that information. Or my sellers, excuse me, chose not to disclose that information. Questions? Comments? Right. Break time. Take 10. All right. I've been so jealous all weekend with Lauren sitting outside. I've just been like, oh, that looks nice. Are you here in the triad?
Yeah, I'm in Greensboro.
Bro?
Mhm,
That's
Yeah.
nice.
Yeah, it feels pretty good out.
I love that we can be outside in June and not, I mean, it was warm last week. I know it's going to get warm again, but we might get back down in like the 70s this week or something. I think there's a little cold front, so that'll be a nice reprieve. Now that my AC is working, it's gonna it's gonna cool down again. Isn't that how it goes? All right. Any questions on our misrepresentations, omissions, material facts? What is and is not a material fact? Okay. Another little section we're just going to mention briefly. There's something called the North Carolina Planned Community Act. And what this act does, it expands owner association authority and covenants, enforcement power. So owners need to explain to prospective buyers about the association. One of the best ways they can do that is how? Provide them with the covenants, provide them with the bylaws, the covenants. Buyers have a right to know what they buy. And if they buy in an HOA, they have the right to know those rules. And that's pretty much what this act is saying. Remember, your RPODs will assist with the owner association information. If it's new construction and the RPODs isn't required, that's when you have that owners association disclosure. So we got a form for that. Another little subtopic here in North Carolina is about subdivisions and subdivision regulations. We're also going to talk about streets. So there's a few things about street disclosure that we need to know in North Carolina. First off, let's talk about what a subdivision is. A subdivision is defined as a division of land into 2 or more lots. Maybe it's 2, maybe it's 200, but you're taking one piece of land and you're dividing it into 2 or more lots for the purpose of sale or building, either now or in the future, or any division of land involving the dedication of new streets or the change in existing streets. Again, we're going to talk about streets in just a second. So you're either taking a piece of land, dividing into 2 or more lots, or you're dividing the land and doing something with streets. That's going to fall under the definition of a subdivision. So if that's what a subdivision is, let's talk about what a subdivision is not. That definition excludes any division of land into parcels more than 10 acres with no street or right of way, or a division of tract in a single ownership, no greater than 2 acres, no more lots than 3 lots, again, with no street right of way. These would not fall under the category of the subdivision. The developer of a new subdivision has some requirements, particularly those with recording information for the subdivision. The owner needs to record the final plat with the Register of Deeds prior to selling the first, prior to conveying, let's be sure we're clear, prior to conveying the first parcel of land. We can go under contract with a preliminary plat. We cannot close and the first unit of a new subdivision without having the final plat map recorded. Everybody hear what I'm saying? The difference? We can go under contract with preliminary. We can advertise, we can promote, we can go under contract. But before you sell the first lot or the first home in that subdivision, the final plat map has to be on record. A buyer deserves to know what they're buying. Again, we'll talk about streets in just a second, whether or not they're public or private. So we'll talk about that. There are penalties for the developers that sell in an unapproved subdivision. There are penalties involved. If they sell in county or municipality that has a subdivision ordinance, they need to get approval. They got to go through the zoning. They got to go stand in front of the city. Again, you guys, there's a whole lot of work that goes into it before you and I ever see the crews show up and start working. They have to have all this approved and figured out before they can actually start clearing the land. And again, we got to have the final, but the preliminary, we need to have something to show the buyer, even when we're advertising the property. So we can have the preliminary to advertise and market. We can have the preliminary to go under contract. We got to have the final before we're ready to sell the first unit or the first lot, the first property. So contractors have to require, there's several contract conditions that developers, again, they have to have that copy of the preliminary. We can't close before we have the final. So what if the buyer goes under, whoops, did I skip one? Buyer goes under contract with preliminary, and then there are changes made before the final. Well, the buyer should have the right to terminate if those changes could affect why the buyer thinks they're buying. So we may have preliminary covenants. We may have preliminary plat maps. Everything may be preliminary. And if there's any changes made, then the buyer needs to present it with those changes. And they need to decide if they agree with them, if they're good to agree with them or not. If they want to move forward. So the rules will say for developers, allow a buyer 5 days to close after delivery of the final, or 15 days to terminate with full refund if there is a change from preliminary to final. So 5 days to close after delivery of the final. That gives them time to look at it. That gives them time to ask questions, call their attorney, reach out to the developer, whatever. So once that final's ready, we have anything on the books to close, we can go in 5 days, or 15 days to terminate if there's any changes made from the preliminary to the final. When it comes to subdivisions, our responsibility, broker's responsibility with subdivisions, we're going to help verify the approval status of the plat map. We know we can go to the Register of Deeds. It's always the best place to start. Some counties are easier than others to navigate around the Register of Deeds. Just when you think you got one county mastered, Then you have a buyer that wants to buy in a different county. You go to the register of deeds and it's like starting all over. So every single county is different. There is zero uniformity from county to county. And again, we can go under contract with the preliminary. We had a developer, we had preliminary stuff, buyers were starting to come around. Man, we had our documents and we had like a big purple preliminary written across the top of it. So anybody that got their hand on this knew that it was not the final. We were still under discussion. We're just letting people know we're getting there. We're working on it. Just real quick, we're not gonna spend much time on this, but basically there's 4 stages when a developer is developing a subdivision. There's pretty much 4 stages: the initial planning stage, the final planning stage, startup. That disposition startup is usually when you and I start seeing them work. So they've already been through several steps. Again, getting approval from zoning, from the city. Does it meet the city's master plan? Is it part of their where they see themselves? It's a process. Can we get utilities? Get a survey of the land, make sure we can build on it. That's all part of those initial and final planning stages. Anybody a developer or work with a developer or thinking about getting into development? Maybe, yeah. As you can imagine, if that's the route you go, there's further education out there. So just make sure you're getting the training. With subdivisions comes street disclosure laws. So let's talk about streets in a subdivision. If a developer plans to dedicate subdivision streets to public use, street construction has to comply with NCDOT standards. We're going to talk in just a second about whether or not DOT will assume responsibility for the road. But if the builder doesn't build the roads according to their standards, I'm telling you right now, DOT will not assume responsibility. And DOT comes out periodically throughout the project to make sure that their streets are being built to their standards. Makes sense, right? If you're asking them to be responsible for them and maintain them, then they're going to have certain criteria and guidelines on how they want them constructed. Makes sense to me. So the developer needs to let the buyer know if they intend for the streets to be public or private. Please know, when we talk about public or private streets, we're not talking about whether or not you can drive on it or not. We're talking about whether or not DOT will maintain the responsibility, will assume the responsibility of it. So if it's public, NCDOT is maintaining it. If it's private, the homeowners that live on that street is maintaining it. How they maintain it is going to be spelled out in the covenants. Is there part of their HOA? Are they going to have a special assessment whenever they get a pothole? That's all got to be spelled out in the covenants, the how they're expected to maintain it. For us, who is going to maintain it, public or private, is a material fact. So we do need to disclose that. Just because the developer wants the streets to be public does not mean DOT will accept them. If you're working with a buyer that's looking at a home in a new subdivision, we need to be very careful about what we say. The streets are intended to be public, but we won't know for sure if DOT is going to pick them up until the project, that phase, is complete. I can't make guarantees. I do not have a crystal ball. I can tell you this is what the developer wants, and they're constructing them according to those requirements by DOT, but I can make no claim that DOT will take responsibility. Fingers crossed. And that's where I think in this conversation with our buyers, it's important that we understand the difference between dedication versus acceptance. Streets can be dedicated to DOT, which means the developer wants them to take responsibility. But DOT is not going to actually take on responsibility until they've accepted that. When are they going to accept it? When all that building equipment is out. Have you guys ever driven through a subdivision being built and there's like a curb, like space in the curb, and maybe the manhole covers, you got to watch where you're driving because there's a big chunk of that showing. They've put down a layer of concrete so the big building equipment can get in and out of the subdivision to build. So they put down concrete so we can, construct. Once all that equipment's out, then the developer is going to come in and put down the final layer of concrete. And that's when all those gaps on the curb and the manhole covers get filled in. Once that final layer of concrete is put down is when DOT is going to come out and say yay or nay. They're going to accept it. So let's be very clear. If a street's been dedicated, it does not mean that anybody has accepted responsibility. They will only do that when the project is complete. Do I have questions on that?
This may be silly, but DOT is a state or a city?
Either one. Usually we have the Department of Transportation is North Carolina, but you could have a municipality. You could have a more local that maintains the streets. But usually when we refer to DOT, we're referring to the North Carolina Department of Transportation.
Oh, okay.
A question comes in, and this is a good question. Is there a good way to determine if a road is publicly maintained by DOT? That can get tricky, right? You may be able to find out on DOT's website. You may be able to get that there. You may be able to go back to the developers, if you can find in, the covenants, maybe the bylaws. Sometimes it's harder to find than others. I hear what you're saying. So I would start with DOT, check out their site. This has become a big deal within the last 10, 15 years. People bought houses in new subdivisions like back in the 90s and early 2000s, and they thought they were buying with public streets. That's what they were told. The developer told them, the agent told them. They were dedicated, and everybody assumed DOT would take responsibility. Well, the phase was finished. DOT didn't pick it up. There we go. And so now they're private. So people thought they had public, but come to find out they're private. Now, fast forward 20 years, we're starting to get potholes, right? Streets need repaired. And the homeowners are going, yo, DOT, where are you? And DOT is saying, that's not our road. That's not our responsibility. So now these homeowners are going after, and I can't blame them. They're going after everybody that was involved. They're going after the agents. They're going after the developer. They're going after the builder. They're going after everybody because now they found out that they are the ones responsible when they were told that DOT would be. Does that make sense? So because of what's happened in the past, now it's a big deal today that we properly disclose, that we make sure, especially in new subdivisions, that we have these conversations. They're dedicated, and fingers crossed they'll accept them. But there are no guarantees until that all the work is done, all that big heavy equipment is out of there, and the final layer of pavement is put down.
So what happens in a situation like that? You purchase under the knowledge or understanding that they were going to be public roads in your development. And now, so what happens with the snow? Who plows it?
Exactly. They think DOT should show up, but DOT is saying that's not my road to plow. So now they have come together and hired attorneys. Subdivisions have hired attorneys. And like I said, they're going after everybody, builder, developer, agents, everybody that was involved, trying to get some money to fix their roads, because they were told it would be maintained when they bought.
So what would be the result? Or what has this happened before?
Oh, absolutely. This is happening today as we speak. So it's however the judge rules, right? The judge either tells them they have a right to collect and they can sue, or they say, sorry, folks, you better fix that pothole. Yeah, this is happening all over the state. Again,
Can you go afterwards and get the DOT to accept, like meet their requirements or
maybe, but you would probably have to reconstruct the road because there's a reason they didn't accept it the first time. So you'd probably have to reconstruct the road. And now the question is, who pays for that?
Oh,
Can
that's
can
horrible.
the buyer's attorneys get the developer to come back and fix whatever? Again, they were dedicated, but for whatever reason, there was a condition in that road that DOT didn't accept them.
That's horrible.
Isn't it?
Mhm.
This is one of these things. This showed up. This was the number one topic in a CE class. I don't know, 5-8 years ago, something like that, because of. So that's why, again, we learn from our past. And that's why we now know that not claiming DOT will accept responsibility, but making sure buyers understand that's the intent. That's what we hope, but there is no guarantee. And if buyers don't like uncertainty in their life, maybe they don't buy in that subdivision, or maybe they wait and buy when DOT is accepted. You guys with me? I cannot make any kind of guarantee on this. So again, when it comes to street, our responsibility, reasonable inquiry. Any adjacent street is not a material fact. So it's usually just the street that the homeowner lives on, maybe that subdivision, right? If we're just buying in the subdivision, we don't care about the subdivision next door. We just care about this subdivision, this DOT. And guys, keep in mind, if the subdivision was built in different phases, then each phase has to be accepted, right? It's not just the whole subdivision in a whole, it's phase 1, phase 2, phase 3, phase 4. And then we just have a duty to disclose. New construction and resale. Questions on streets and subdivisions? A little subtopic within this unit, we're going to talk about some environmental laws. A lot of this is more here, FYI, if you deal with any of these, and a lot of these might be regional, depending on where you are. So for example, one environmental law that we have is the North Carolina Coastal Area Management Act, so known as CAMA. This requires a permit prior to engaging in development of any area of environmental concern. So if you want to develop down at the coast, environmental rules says that we need to also honor the coastal area, getting permits to develop or grow in any of our protected areas of the coast. Let's go to the opposite end. We have the North Carolina Mountain Ridge Protection Act. First off, go North Carolina. We were the first state to enact some kind of legislation to protect our mountain ridges. So yay, NC. We did that one right, I think. But there could be restrictions or regulations when building in the mountains, environmental issues to be aware of. There's a waterway vegetation buffer zone. The purpose of this is to help minimize pollution, maybe a buffer zone to not disturb vegetation. Like, for example, you can see some vegetation around the river or coastal areas. That might be a protected area. Help keep that vegetation safe. So for example, this zoning area may say you can't build anything, closer to 30, 50 feet away from, this area. So they may have like a setback, right? But the setback wouldn't be from the street. It would just be from the river or body of water. We have scenic corridor zones. So it limits land use within our scenic corridors. I think of our Blue Ridge Parkway for scenic. You talk about leaf season. Try trying to drive down the Blue Ridge Parkway in fall. I think the one that affects us, and again, this is one of these things, this became a big problem just within the last, 10 years or so, is our underground storage tanks. This is regulated by the North Carolina Leaky Petroleum Underground Storage Tank Act. Underground storage tanks are very common. Maybe they're still in use, maybe they're not. It might be that they were buried at some point, out of sight, out of mind, right? Problem solved. The issue is these are usually made of steel. Eventually steel corrodes. And if there's any contents in this thing, oil or gas, for example, then it's going to leak out into the ground, get into our groundwater, possibly contaminate our drinking supply. So there's this act in place to regulate how these things are handled. Do they need to be removed? Do they need to be filled? There's various ways. They do provide funds to help owners with cleanup. They would have to apply. No matter where the oil or the gas leaks, the owner of the property of where it started is responsible for it. So if it leaks and the neighbor and the neighbor's neighbor and the neighbor's neighbor's neighbors, the owner of the property where it originated is the one that's responsible for that cleanup. And again, there's funding they may be able to apply for. But with these, again, owner has liability for cleanup, even if they weren't the one that put it there. If you're walking in somebody's backyard and you trip over a pipe coming out the yard, stop and ask questions, because that pipe is going somewhere. That pipe goes somewhere, and it's probably some kind of underground storage tank. Maybe that one's still in use, but like I said, there's lots of these things that are no longer in use that we buried in the backyard because we thought that was a good idea back in the day. And now we're learning. I think I saw once that it's guesstimated that there are about 1 billion underground storage tanks across the country. So now we as listing agents don't have to go out there with our metal detector and look for it, right? But again, if you trip over a pipe coming out of the backyard, ask some questions. And a funnel and kitty litter are not how you remedy underground storage tanks. We need to bring the professionals in. I'm not going to say I've heard it all, but just to let y'all know, funnel and kitty litter is not the answer. We have the North Carolina Sediment Pollution Control Act. This helps when we redistribute land. How to sediment land, when you move land and water flowing is going to change in the flow, and redistributing land and soil. And so there's acts. Acts in controlling sediment. We have something called the Clean Water Acts. This requires a permit to dredge or fill in wetlands before you disturb the earth or the water. There are acts and rules for wastewater systems. Where does our water go? If it's not an on-site septic system, is it a public sewer? Is it community sewer? Maybe you have one treatment plant for a community. Something called straight piping. If you see straight piping, there's piping going straight from the water source to a nearby creek. I think where we tend to see this most often is maybe from a washing machine. The washing machine may not be hooked up to the main water exit. And instead it might be straight piping. Straight piping is illegal. Water needs to be discharged through the proper channels so it can be treated. If we come across that, it's a material fact that we have to disclose. Again, pipe coming from the house, going to a creek or a river, ask questions. So when it comes to environmental issues, are we liable? That was supposed to be animated so you guys get a chance to answer. Are we liable? Well, we are not expected to be environmental experts, right? We need to have a general knowledge of environmental laws and rules. But remember, we always have that duty to disclose. So once we learn of an environmental issue, then we have a duty to disclose it. And again, working with sellers, there's that duty to discover and disclose. So don't turn your eye to that pipe sticking out of the ground. Don't ignore the straight piping coming from the house. That's our duty to discover and ask questions. Typically with environmental issues, the homeowner, the owner of the property, I should say, is more responsible than you and I. Our responsibility is to disclose. Questions on this? Have a little subcategory in this section. We're going to talk about fair housing, specifically state fair housing. But before we talk about state, this is NAR's fair housing logo. If you are a member of NAR or when you become a member of NAR, know that NAR is a plethora of information for fair housing. There's some designation and certification courses you can take. For example, At Home with Diversity is one of their I think it's a designation, maybe a certification. Is it a designation? Okay, so it's one of their designation courses. They've also, I think it was like 2020, they released, it's kind of cool. It's a simulation. You guys remember those choose your own adventure books? So it's kind of like that, but it's called Fair Haven. And Fair Haven is simulation. You are the real estate agent of a fictitious town called Fair Haven. And this walks you through various scenarios of working with buyers and sellers of different colors, different religion, different races, different sexual orientations. And you're working with these buyers and sellers and responding to various concerns. And it's a really good simulation. I mean, I want to say it took me a little over an hour. So, you know, you need time to sit down and do it, but it walks you through. And if you don't answer appropriately, then they just aren't going to say wrong. They're going to tell you, you know, how you could have answered better the next time in that situation. So use NAR as a good resource for fair housing. Again, specifically, we're going to focus on state fair housing. Is everybody good? You got federal fair housing and then you got state fair housing. So with state fair housing, the good news is state fair housing and federal fair housing are identical. So our protected classes are the same in North Carolina as they are federal. There are other states like California, they have like 12 protected classes. So they have more protected classes than federal fair housing. So the good news for us is that federal fair housing and state fair housing has the same protected classes. And I think how we all like to remember those protected classes is by remembering fresh corn. The F in fresh corn is familiar status. What does familiar status have to do with?
Children or families under 18.
Children, pregnant women, any families with children or pregnant women. Familiar status does not protect old people. Familiar status protects those under 18. And that does include pregnant women or, fetuses. Race is referring to somebody's origin, where they hail from, if you will. Sex is a protected class. And as of February of last year, sex in federal and state now also includes sexual orientation and gender identity. So sexual orientation and gender identity are now protected under sex, under state and fair housing, federal housing. Handicap and disability status is a protected class. The color of somebody's skin is a protected class. An individual's spiritual beliefs are a protected class. And then your national origin. What country do you or your direct ancestors, where did you derive? This is what's important to know about fair housing, both federal and state. Fair housing does not say, these are the protected classes, don't you say anything bad about them. What fair housing says is, these are the protected classes, do not say anything at all. We can talk about the property all day long, but when it comes to talking about the people, we need to be very careful that we're and mindful of the protected classes. If there's a category that's not one of the protected classes, then we don't have to be mindful of it. For example, is political affiliation a protected class? No. About almost 6 years ago, my husband sent me an advertisement for a home for sale in California. And the public remarks said, Trump supporters not welcome. Did they violate fair housing?
No.
No, no. Did they have buyers? Did they probably change buyers? Two buyer was away because they don't want to deal with this person? More than likely. But there were no violations. There was nothing, despite what we may think, there was no fair housing violation. That's what I need us to understand. It's just the protected classes. If not a protected class, there is no violation. Everybody with me? I wouldn't want to work with that seller, whether or not I'm a Trump supporter or not, that doesn't matter. I wouldn't want to work with that seller because that seems like that might be a difficult transaction. So could she have limited her pools of buyers? Absolutely. But the point is they didn't violate fair housing. Any questions on that?
Could that be interpreted as race?
Not unless you throw something, but if you just say, something political, you could say no Democrats, right? And that couldn't be. So, I mean, I guess you could try, but the wording is what we're looking at here. You know what I'm saying? You could imply various things, but the actual wording would be what we're going to look at here. what if you have an apartment to rent and you don't want real estate agents to rent it because we don't get paid every other week. We get paid when it closes, and you put in your ad, realtors not welcome. Is that a violation of fair housing?
No.
Because you're not selecting which realtors, right? Color, religion, national origin. You're just saying all realtors, but occupation is not a protected class. Again, are you limiting your pool of buyers? Are you upsetting people? Probably. The point I'm trying to make is you're not violating fair housing. In North Carolina, there's some exemptions. First off, there is no exemptions for the for sale by owner. So in North Carolina, the for sale by owner has also got to follow fair housing. In North Carolina, there are exemptions if you're renting a 1 to 4 unit. If you or one of your immediate family members are going to live in the unit, you can choose who lives there. And there's also an exception for our single sex dormitories. Think of our college dorms, military barracks.
So there is so there is an exemption. No.
Yes.
Wait.
You don't
Okay,
have to
got it,
follow
got it.
fair housing. If you're renting a room, a single sex dorm, or a unit that you or one of your immediate family, you do not have to follow fair housing. However, guys, please remember, you can never advertise your discrimination. So if you have a duplex and you're living in one of the units, you don't have to follow fair housing about who lives in the other one. However, you can't in your advertisement say men need not apply, right? You don't have to allow a man move in or apply, but you can't advertise that. Does that make sense?
Right.
You can never advertise your discrimination. Again, federal fair housing says the FSBO doesn't have to follow fair housing. State says there is no exception. So if the FSBO is selling a home in North Carolina, they abide by fair housing. It's a state law, not a federal law. Fair housing at the state level is enforced by the North Carolina Human Relations Commission. And as with any law, this is not specific to fair housing. If you ever have a conflict of laws, the more restrictive will prevail. So the stricter, whatever the conflict, zoning versus covenants, federal law versus state law, any conflict of law that you may ever encounter, the more restrictive of the two will prevail. Questions? If we look at the commission's website, again, publications, our Q&A brochures, we've looked at quite a few of these. We're not going to go through it, but I think this is one of the more important ones that we have to share with our buyers and sellers. Particularly, I think fair housing issues come up with sellers. Have you guys encountered the seller yet that says, I don't want to sell my house to somebody, a member of the protected class? Have you come across that seller yet?
Yep.
Yep. They're out there. They're everywhere. And if you haven't encountered one of those sellers yet, you probably will. And we need to know how to respond. Seller, I hear what you're saying. We can't discriminate, but, we're going to consider all offers. Who the people are making those offers doesn't matter. What we care about is, can they afford to buy? Are they making the offer that's suitable to your needs, right? So we can explain to the seller that the actual person making the offer shouldn't matter. If your seller insists, no, 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 I'm not going to sell my house to fill in the blank of a protected class, we may be best to walk away.
Mhm.
Because when that seller goes down, they're going to take themselves down and they'll take you down with them. So we have some of these tools, like for example, this brochure that can help us with those more difficult transactions, those more difficult clients. I don't know why I wouldn't want to work with somebody that was like that anyway. I mean, truth be told, I'd be happy to part ways. But this could be a license violation. This could be a court or a civil lawsuit, right? This could go further than what that one listing commission is going to provide you. Does everybody hear what I'm saying? The lease side of it, I think where we encounter this the most is trying to find tenants. You know, you may have a landlord that says, I don't want to rent to anybody with kids because kids are going to destroy my house and they're going to put crayons on the wall and, you know, all the things that kids do. Can we say rental unit available, no kids or no families allowed? Can we see? And that's another conversation. You know, you can't deny a rental because the family has kids. Okay. And again, I think a lot of this, a big part of our job is to educate the consumer on various issues. And one of those issues that we have to educate the consumer on is fair housing, whether you're going for sale or for rent. Because bottom line, once the consumer gets you and I involved, there are no exceptions. There are no, well, maybe, you know, because I'm a for sale by owner. Once you and I get involved, there is no violation of fair housing. So use this. I do recommend you guys come to the website and check this one out, of course, after your exam, but it gives us some good definitions. And again, this is just a tool that we can use if when you're dealing with the consumer, helping to educate them, and particularly that possibly difficult consumer. Questions or comments on that? We are finished with the material. Yay. So let's take a break. Let's take 10. We come back. We're going to do our review. We're going to talk about the exam. We'll break for lunch, and then we'll just have the afternoon to take the test. Does that sound fair? Can everybody maybe go into lunch about 1-ish, something like that? Can everybody hang out with me that long? And then we'll break for lunch once we do the review. And then when we come back from lunch, then all we'll have to do is the test. Is everybody good with that? My plan? Okay. All right. Let's take 10. I got just turned 12 o'clock. So let's come back at 12:10 and we'll focus on your review. All right. I wanted to point something else out, back to fair housing real quick. In your manual, in your manual, chapter 18 is all about fair housing. So there's another good resource in your manual as well. If you're digital, then it's the chapter 19. But there's some good case studies in here. So you guys are, a case study is from actual events. So I think looking at the examples, looking at the case studies, also kind of help us better understand that, the examples, various things. So make a note, chapter 19 is all about fair housing. Okay. So we are going to do our exam review. I know we've talked about a lot in our short time together. Some of it was brand new. Some of it should have been a really good review. So what we want to do now is kind of hone in on certain topics. Again, honestly, you guys, I mean, we're going to get you through the test. That's not the issue, but it's more important to me that you guys have an understanding of this stuff so you can use it in your practice. You can use it in your day-to-day business. So please don't look at this as I just got to get through the test. If you want a long-term career in real estate, then you have to understand and be familiar with the law and the rules. Fair enough? And those things change on a regular basis. So like we said, we know next week we got forms changes coming. Changes are just inevitable. Okay. So let's review. What are some things we talked about? Well, one of the very first things we talked about together was who needs a license. You guys remember our formula? You remember our activities? Any transfer of real property for others for any form of consideration. I fear this is misleading. It's consideration. It's not just money. It's anything of value. So for example, we've talked about in exchange for rent, free rent, or, you know, whatever is something of value. So it's not just money. All three of these are required to have a license. So again, if you're for sale by owner, you're not doing it for others, you're doing it for yourself. So a license is not required. All three activities is required in North Carolina to have a real estate license. Questions on this? We talked about who's exempt from needing a license, who doesn't have a license. Well, I've already told you the for sale by owner. What are some other people that we've talked about are exempt from a license? Who else?
Guardians.
Guardians, trustees, executors of will, anybody court appointed to handle the affairs on behalf of somebody. Yep. Who else?
Attorneys.
Attorneys, as long as what? Say a little bit more about that.
They're not engaged in brokerage activities.
There you go. There you go. Our closing attorneys don't need a real estate license as long as they're acting as a closing attorney. Now, if they want to go out and help their brother buy a house for consideration, now that attorney needs a real estate license. Does that make sense? So as long as the attorney is doing their job of the attorney, they don't need a license. Similar to what you said first, Sabrina, is the attorney in fact. If you're performing as a full power of attorney for somebody. An example of this might be like me having full power of attorney over my elderly parents or something. I'm in full control of their medical, legal, you know, everything. And I would, as a power of attorney. I think the other one they kind of give as an example, but it kind of rolls into the for sale or for rent by owner, right? If you're an employee of an entity that is managing entity owned properties, you're still doing it for the entity, right? You're still doing it for yourself. So it's not really different. Just want to make sure that we're hearing. So FSBO and FRBO, for sale by owner and for rent by owner. And then again, if you're an entity and you're an employee, an entity that owns property, and you're an employee of that entity, as long as you're working with those properties. We talked about you guys. Some of you aren't going to have your training wheels for much longer, are you? So that'll be good. We're provisional brokers. I think we're all good with this. How do you be active as a PB? And I can see your mouths move. How are you active as a PB? You have a BIC, right? You're affiliated with a BIC. You are supervised, affiliated with a firm and a brokerage in charge. Once you're affiliated with a BIC, you can pretty much do anything that a full broker can do. The key is you have to be under the direct supervision of a broker in charge. Do your head one way or another. Can a provisional broker be a part of a team? Can they be a member of a team? Yeah, absolutely. And remember, a fairly new rule says that a PB can be dual affiliated only if they're a member of the team and the team is under the same roof as their broker in charge. So they can be dual affiliated, one with the BIC of the firm and again with the BIC of the team. But the caveat to that is they both got to be under the same roof. Is everybody good with that? Okay. CE requirements. Do your head. Do you have to do your CE your first renewal period as a PB? Do you have to do CE your first renewal period? Nope, you get your first year off, don't you? You only have to take CE your second renewal period going forward. So whatever day you got your license, the first time you hit May 15th is your first renewal period. The second time you hit May 15th, you have to do CE. Remember, provisional brokers and full brokers do the general update or gen up. The BIC up or broker in charge update is just for BICs. How long do you have to complete post licensing? From the day you get your license, how long do you have?
18 months.
18 months. What happens if you don't do post within 18 months? What happens to your license?
Inactive.
Yep. If you failure to do your post within 18 months of licensure, means your license is inactive until you get your post complete. I don't care if you're smack dab in the middle of a transaction or not. Watch that 18-month clock. If today isn't the end of your third post licensing, make sure you're watching. Your time will and can get away from you. So just make sure you're watching that 18-month clock. Everybody good with that? And then we talked about the BIC. The BIC is the one kind of responsible for everything that happens in this office location. So all affiliated brokers, unlicensed employees, anything within this. We talked about the requirements to become BIC eligible. To become BIC eligible, you have to have an active full broker license. A provisional broker can't be a BIC. Doesn't that make sense? So you have to have an active full license. You have to have at least 2 years of full-time experience within the last 5 years. It doesn't have to be consecutive, but you need 2 years of full-time experience. And then there's the completion of the 12-hour BIC course. So once you meet those criteria, you're BIC eligible. Once you're BIC eligible, you can become the designated broker in charge. There is a rule that allows an exception for that. A broker can become designated broker in charge before becoming BIC eligible, as long as they're active and have the experience. They would have 120 days of designation to take the 12-hour BIC course. To me, that would be an emergency situation. We got to get a BIC in here now. So you call up a full broker, designate them as broker in charge, and they must take that BIC course within 120 days of designation. We just mentioned some of the responsibilities of the BIC. probably the number one responsibility of the BIC is you guys, the provisional brokers. Trust account. If the office is going to have a trust account, all advertising of the firm. Remember whose listing is it? I just gave you the answer. Whose listing is it? It's the firm's. So the BIC needs to make sure that any advertising coming out on behalf of the firm is in compliance. The BIC's responsible for supervising unlicensed employees, making sure they're doing activities that unlicensed employees can do. They're responsible for agency disclosures and agreements of all affiliated brokers, PB or full. And in addition to the BIC, we also talked about the qualifying broker.
Oh, I'm sorry, can we go ahead? I'm sorry, what's the second T in that? The transaction and what? Trust?
Trust account. Yep,
And
they're
then-
responsible for maintaining all of the office files, transaction files. For how long?
3 years.
3 years? Yep.
And the AAA is the advertisement agreements. What's the other one? Accountant?
Advertising, agency agreements,
Active.
active, thank you. Making sure everybody keeps an active. and
Oh,
active
okay.
license. Thank you. Thank you.
Okay,
Including
you.
themselves, right?
right. Okay, got it.
You saw my wheels turning.
I know, I was like, I had to count it and I'm like, that's not right.
That's not right.
Okay.
Okay. The QB, there's one qualifying broker per firm. So we got a BIC per office location, yes, but then we got a qualifying broker per firm. The qualifying broker is a principal of the firm. So they need to have some sort of ownership interest in the firm. Not all owners have to have a real estate license, but the qualifying broker does. If it's for example, an LLC, if the firm is an LLC, then the QB needs to be a manager of that LLC. If it's a partnership, they need to be a general partner. You guys with me? They have to have some sort of ownership, some sort of something to be a qualifying broker of the firm. The QB is the one that's responsible for designating the broker in charges of each office location. So if a BIC leaves, the QB needs to get another BIC in there. Can the QB and the BIC be the same person? Sure.
Yeah.
Absolutely. Do they have to be? No, it kind of depends on the size of the firm, right? If you're a one-man show, you're QB and BIC. If you have 6 office locations with 800 agents, then you are designating that broker in charge for each office locations. The QB is the one that renews the firm's license each year. The QB makes sure that the firm's license renews annually. And any change to do with the firm, change of name, change of address, the QB is the one responsible for notifying the commission within 10 days of that change. To be QB, again, you got to be an owner, have some sort of ownership interest in the entity or the firm. You need to be a full broker. Can't be a PB. And your license has to be in good standing. They're going to do character reference, just like when you got your license. We talked about the firms. All firms have to have an application. All firms have to have All firms have to have a firm license through the Real Estate Commission, as long as they are engaging in receiving compensation, advertising, promoting, etc. The firm needs a license. If you're not going to use your assumed name, your assumed name is your last name, your surname, right? So if your firm name is going to be something other than Campbell's Real Estate, then you need to start with the Register of Deeds to register your firm name. whatever name you're going to use, you need to get approval. You need to get permission to do business from the Secretary of State. It's a whole process to open a firm, register it with the Real Estate Commission. When you get to this point in your career, I highly recommend you check the current license law and commission rule, firm application. The limited non-resident commercial license. This is a licensee with an active license from another state outside of North Carolina that's coming to our state. They're getting a license to do a limited number of commercial transactions, limited non-resident commercial license. They have to connect with a resident broker. In other words, somebody in the state of North Carolina with an active license in good standing has to take them under their wing to make sure they're following North Carolina license law and commission rule. The resident broker can be a provisional broker. They can be a full broker. They can be a broker in charge. Ultimately, they're the ones responsible, as we said, for making sure the LNCL follows license law and commission rules. The LNCL's license must remain active and good standing in their qualifying state, wherever they came from, in order to do business as an LNCL here in North Carolina. And if they do anything that could be a violation of North Carolina license law and commission rule, the resident broker is the one responsible for reporting them.
Responsible for what? Reporting?
Reporting them.
Okay.
Before you agree to be a resident broker, you need to check with your firm's policy to make sure your firm allows that. I think we all agreed we saw the potential liability for being a resident broker. So just check with your firm's policy. When's our renewal period? When do we renew our license?
May 15th to June 30th.
Every single year.
Oh,
Every single year. May 15th, why wait till June 30th, right? We got bombarded with emails. Did y'all wake up to May 15th and go, what just happened to my inbox? Why wait till June 30th? Go ahead and do it. You guys are all good this year. You told me. Next year, do it again, the year after that. June 10th is what?
CEs.
CE, that's right, our CE deadline. Everybody renews their license from May 15th to June 30th. The individual broker, the firm, the BIC, the qualifying broker. Not that you guys need to know this, but educator providers, schools, instructors, we all have to renew. Everybody renews May 15th to June 30th every single year. Okay, so I think we already did this. How long do you guys have to complete post licensing? We've already done that. So just to make sure we're good, 18 months. License status, if you fail to complete, is inactive, right? If you don't do your post within 18 months, you're inactive until you do complete. So we're good there. We also talked about teams. There is no commission rule regulating teams. Some teams are created voluntarily. A couple agents just get together. Some teams are created by creating a team entity, a firm. And that's what we were talking about just a few minutes ago. The provisional broker can be dual affiliated, one with the team BIC, if an entity was created and the BIC has been designated, and then again with the firm BIC. If the team is an entity, all affiliated brokers, PB and full, are dual affiliated. So if a team is the entity, we're all dual affiliated. Any of our agency agreements need to be in both names. The name of the team and the name of the firm. And those affiliates need to advertise under both names. Before my team became a firm, we went out on our own and hung up our own shingle last year. When I signed an agency agreement, Julie Yates Campbell with the Blue Door Group of Wilkinson ERA. It took me like this much space to get all that in there, but I had to get my name, I had to get the team name, and I had to get the company name. We went out and hung our own shingle, so I don't have to worry about all that anymore.
Just the agency agreements?
Mhm.
What about the listing?
What about it?
The listing agreement is the firms.
It's an agency agreement. So our agency agreements are the listing agreement, the buyer agency agreement, and then our property management agreement.
Okay.
Got to advertise in both names, sign with both names.
Okay.
We talked about when we earn a commission, when we can get paid. Remember, if your license goes expired or inactive on July 1st, you may still be able to get paid as long as you brokerage the majority of the deal. You stopped all brokerage activities when your license goes inactive or on July 1st when it expires. And your firm's policy allows it. A provisional broker, if their license goes inactive, they may still be able to get paid as long as they brokerage the majority of the deal. They stopped all brokerage activities when their license went inactive, and the firm policy allows it. Same thing if a PB changes firms. They may still be able to get paid from the old transaction, brokers the majority of the deal, and the firm allows it. They're not supervised by their old firm anymore because the PBs can't be dual affiliated, except if you're on a team. So they're not going to do brokerage activities under the old firm. They cease those brokerage activities, but they still can get paid by the old firm if policy allows. We talked about referral fees, kickbacks, rebates, etc. If we're going to get a bonus, we have to provide full and timely disclosure to our principal. We have to have permission from our principal. If we stand to make more than the agreed upon commission in our agency agreement, maybe a builder bonus, for example, we need to have written permission from our principal, full timely disclosure. Remember, we also said that RESPA laws prohibit us from getting any kickbacks. RESPA is the R in TRID. TRID is a lender law. So RESPA only applies if a lender's around. If you're a property manager, do you have to follow RESPA rules? Is there a lender involved? No, only in sales, right? So as a property manager, can you get referral fees, rebates, bonuses, and kickbacks? Yeah, as long as you disclose it to your principal and get their permission in writing. Everybody with me? RESPA is not around in a for lease situation because it's a lender law. We talked about the various MLSs. We got Triad, Triangle, High Country, Charlotte, whatever y'all call it down east. Multiple MLSs in the state of North Carolina. We only owe commission to members of our MLS. Commission outside your MLS is not guaranteed. Do we have to pay somebody outside of our MLS? No. Can we? Sure, if the firm policy allows it. So before you go show property outside your MLS, pick up the phone and make sure they're going to pay you. Before you pay anybody inside or outside of MLS, we need to make sure that they have an active license. So if you're going to pay a referral fee, go to ncrec.gov and look them up, see if they're active. Or any state's real estate commission's website.
Oh, that's what that was about.
I don't know if she knows she's on mute, off mute. Do you? Okay, good. Just want to make sure you say. we all heard it was cute. Your little light bulb just turned on and we all saw it or heard it. Okay. Allowable activities of the unlicensed employee. Why don't you guys give me some examples of things that the unlicensed employee can do?
Fill out contracts, but not alter anything.
Yep, they can fill in pre-printed forms, right? As long as the information was provided by their employing broker. What else did I hear?
They can prepare documents and schedule.
Yep, they can prepare documents, they can get stuff together, they can schedule appointments, closings, showings, whatever. What else can they do?
They can show lease or property for lease only.
Yep, properties for rent cannot show properties for sale. Can the unlicensed employee maintain the trust account? Can they manage the trust account?
No.
Sure they can. Who is responsible for it?
Oh.
The BIC is responsible for it. The BIC can allow the unlicensed employee to maintain it and manage it. But when the real estate commission shows up, who are they wanting to talk to? The BIC. So the BIC needs to make sure that their unlicensed employee knows what they're doing with that trust account. Can the unlicensed employee, as part of their job, calculate and distribute commission checks to brokers? Sure, as long as they're working under the supervision of their broker in charge. You guys with me? They can distribute, they can cut the check, they can pay or direct deposit, whatever fancy way you guys are getting paid commission now. There is a lot they can do, but remember, the employing broker is the one that's responsible. And guys, if a employee has a real estate license, if that license is active, they're going to be treated as a broker. If that real estate license is inactive or expired, they're going to be treated as an unlicensed employee. So if you hire somebody and they have a license, you need to dig a little deeper and see if that license is active or inactive. Because inactive is going to be treated the same as an unlicensed employee. Questions on that?
So they're not considered unlicensed, they're just an employee.
Because they're inactive or expired. So the commission can't regulate them unless they have an active license. We talked about the North Carolina Commercial Real Estate Broker Lien Act. This is the act that allows the commercial broker to file a lien on a commercial property to protect their commission. It's only the listing or leasing firm that can file the lien. The buyer's commercial agent cannot file a lien. So it's just the list side. This is a low priority lien, which means you get paid when? Last. You're at the very end of the line, aren't you? It's a low priority lien.
So I think there was a question in Well, I know there was a question in LTP this morning. I was going through it, and not unless I read it incorrectly, and I did take a picture of it. It said that the broker was representing the buyer. So would they be entitled to would they be able to be entitled to the Broker Lien Act? So I selected no because I thought it was for sellers.
So let me, if you have it, I'm happy to look at
Mhm.
it. Not now. I can look at it on our lunch break. But I want to make sure I'm telling you guys right for this afternoon. So let me, if you know that number, whatever, let me know and I'll look at it at lunch. But for this afternoon, the listing and leasing firm. Because remember, you guys, the listing agreement says the seller's going to pay the listing firm shares their commission with the buyer, right? So the buyer has no relationship with the seller. And that's why it's just, so I'm not saying learn, test, pass is right or wrong. I'm just saying, let me take a look at it. But what we need to know for this afternoon is the listing leasing firm is who can file the lien. Okay. And again, if you get that number or where I can find, I'm happy to look at it. Thank you for bringing that up.
Okay, so it's for the seller. Okay, which is what I thought. But
If it's a lease transaction, the firm can file the lien within 190 days of tenant possession. I'm sorry, 90 days. A lease transaction, they can file the lien within 90 days of tenant possession. If it's a commercial sales, then they can file the lien no sooner than 30 days prior to closing. So there are requirements, 90 days from tenant possession or 30 days prior to closing. Anytime, if you're a commercial agent, you're getting involved in this, you're going to want to get an attorney involved. Can full brokers be dual affiliated? Can full brokers be dual affiliated? I'm seeing head shake, yes, as long as we have consent from both brokers. That's the key. You have to have permission from both brokers to be dual affiliated. Again, the caveat to the PB, they can be dual affiliated, both BICs under the same roof. That's the only time that dual affiliation is allowed with a provisional broker. Both BICs are under the same roof.
consent from both firms, you said?
I'm sorry?
You said can a full broker be dual affiliated? And you said yes, if there's consent from both firms, did you
Both
say?
BICs, both BICs,
Oh, both, okay.
both firms, yep. We talked about the disciplinary action. The dreaded brown envelope is what we call it. It has a technical name. What's its technical name?
Letter of inquiry.
Letter of inquiry. This is not the disciplinary action. This is saying, this is our letter to you asking you to share your side of the story. There's been a complaint filed. We're not disciplining you yet. This is your opportunity to share your side of the story. So your letter of inquiry, you respond to the claim, to the complaint with your documentation, because let's say it one more time. Once again, for the guy way in the back, what are we documenting? Everything. You guys will thank me one day if you ever get this brown envelope. Okay, I hope you never do. But if you do, your documentation is what's not going to have you in the disciplinary action. Everybody with me? Yes, Julie. Okay, all right. We talked about condos and townhomes, and we talked about the differences of the two. Condo owners own airspace only inside the unit, wall to wall. Townhome owners own a little bit of land. They have air rights. Condo owners own the common areas with other owners as tenants in common. Townhome owners do not own the common areas. Who owns the common areas with townhome owners? HOA, you guys are so cute. HOA, that's what I see. The HOA owns the common areas in the townhomes. And you know, condos and townhomes, don't just think they're residential. You could have commercial condos, you could have commercial townhomes as well. So this isn't just residential, various structures. What's this make you think of? Timeshares? What do we know about timeshares? The right to occupy at least 5 separate time periods over at least 5 years. The buyer has 5 days to rescind their contract. The developer has to keep deposits in the trust account for 10 days. Timeshares, just like any real estate firm, they can have unlicensed employees doing various activities. The salespeople sell. Unlicensed employees can do various activities. They have a project broker that acts as the broker in charge. I think one of the other really unique things about the timeshare, this is the only time that the Real Estate Commission will fine anybody. And they have the right to fine a developer. How much? $500 per violation. $500 per violation. We talked about manufactured and modular homes. Manufactured, formerly known as trailers. Manufacturers were built in whole in a factory. They're built in whole. They hook up to the hitch of a truck. They're rolled to the property. As long as they're still on a hitch and wheels, and they have a title with the DMV, Department of Motor Vehicles, they are still considered personal property. Once you remove the hitch, when you put it on a permanent foundation and you cancel the title, you have converted that manufactured home from personal property to real property. Modular homes are built in sections, maybe room by room, floor by floor. And once they're assembled on site by the builder, then they become real property. Manufactured homes are regulated by HUD, Housing of Urban Development. Modular homes are regulated by state building codes. We talked quite a bit about commercial, particularly we talked about commercial office space. We talked about in an office space, we talked about some new terms. So for example, we talked about the floor plate, which is the size of the whole floor, measured from the exterior wall. The core area is that space designated for building functions. Lobby, elevator, stairwell, mechanical room. So in office space, the usable area is the floor plate minus the core area. You take the whole space, You deduct out what you can't use because it's already designated for an elevator. And that's your usable space. Oftentimes, your rent is based on the whole area. Usable space plus your core plate. We spent a lot of time yesterday talking about the Residential Rental Agreement Act. Particularly, we said in the Residential Rental Agreement Act, the parties cannot waive their duties under the act. And what are the parties' biggest responsibilities? The tenants is to pay rent. The landlords is to provide fit and habitable conditions. Those duties cannot be waived or altered, even by agreement. Tenant cannot withhold rent until repairs are made. Remember, you stay, you pay. You pay, you get to stay. We talked about the North Carolina Vacation Rental Act yesterday. The Vacation Rental Act is very similar to the Residential Rental Agreement Act. It parallels it in many ways. The big difference is vacation rentals are usually much shorter term than residential rentals because of the nature of the vacation properties. The act does allow for expedited eviction, get the tenant out faster. The landlord needs to give the tenant 4-hour notice to vacate the property. If after 4 hours they've not vacated, they can go to a magistrate, proceed with the legal proceedings. If the magistrate finds in favor of the landlord, the tenant usually has 2 to 8 hours to vacate from the magistrate's ruling. And if they don't go, we're going to send the sheriff over to get them out, have the sheriff remove them. We talked several different ways that rent gets paid, commercial lease and residential lease. One of those ones we talked about yesterday was the percentage lease. The percentage lease rent is made up in 2 different ways for payment. There's the base rent. It's the same every month, X amount per month. And then the second piece is usually a percentage of the tenant's sales. Can be gross sales or net sales, whatever we agree to. We talked about forms of ownership and how they relate to North Carolina. We said Tennessee by the entirety was the default for married couples that take title. Does that mean this a married couple's only option? Could they choose to be tenant in common, for example? Sure. Tennessee by the entirety is the default, probably the most common for married couples. Joint Tennessee in North Carolina is a little bit different than joint Tennessee in other states. Joint Tennessee, you may have unequal interests. It has to be added. And in North Carolina, the right of survivorship has to be purposely created. It doesn't happen automatically. Remember, we said right of survivorship, 2 people, 2 or more people own a property. Something happens to one, right of survivorship says it automatically goes to the remaining owner. If you have 3 people, I don't know if I can do this. Y'all watch my fingers, make sure I don't flash the wrong one at you. If you have 3 people that own property and one of them passes away, their interest, if we have right of survivorship, it automatically goes to the remaining. You guys with me? That's what right of survivorship says. I don't care what this will says, what heirs say. Right of survivorship says when one owner dies, their interest goes to the remaining owners. When this one dies, now we got one left that owns the whole thing in severalty. Right of survivorship. Did I hear a question? Way back to this morning, we talked about seller disclosures. Particularly, we talked about our RPODs and MOG. Does the seller have to disclose? No, not North Carolina. Why? Caveat emptor. That's why it's so important that we understand caveat emptor. It's not us being fancy and throwing big words around. It's understanding what that caveat emptor says, especially if you're working with buyers from another state. So the Real Estate Commission, North Carolina Real Estate Commission, has provided us with the RPODs and the MOG for us to use for our seller disclosures. What makes them unique? They're mandatory forms with optional disclosure. Failure to provide the form could give the buyer an out. It could give them a reason to cancel the contract. Also, way back this morning, we talked about things that are material facts. The property itself, anything about the property itself, anything relating directly to the property, anything to do with the ability of the principal to complete the transaction, anything of specific importance. And with that conversation, we also talked about things that are not material facts in North Carolina: our stigmatized property, convicted sex offenders, and square foot. We talked earlier about subdivisions. Subdivisions is taking one lot and dividing it into how many or more lots. What's the bare minimum to call it a subdivision? 2. Anytime you take a lot and you divide it into 2 or more lots, it very well could fall under the category of a subdivision. Under that conversation, we also discussed streets, whether or not they're private or public. Again, you guys, it has nothing to do with whether or not you can drive on it. What we're discussing is who's going to maintain it. NCDOT, if they're public, they've accepted responsibility. If they're private, maybe DOT didn't accept them, or maybe they were designed that way. It's up to the developer if they want their streets to be public or private. And just because they want it to be public doesn't mean it's a guarantee. DOT still has to accept the responsibility. And then maybe a whopping hour ago, we talked about some environmental laws. In any area that you're working that's impacted by environmental laws, you need to be familiar with that. That's that reasonable skill, care, and diligence. So if you're down at the coast, there's some coastal environmental laws. If you're up in the mountains. Bottom line, the owner of the property of where the hazard started is responsible for cleanup. If it's on their land, if it's originates on their land, they're responsible no matter where it goes. When it comes to any environmental issues, our duty is to disclose. Always be alert for your red flag. Whenever you have a red flag, that should entice you to ask some questions. And then 40 minutes ago, we talked about North Carolina fair housing and some of the exceptions, what's different or what's exempt in North Carolina versus federal. Federal allows the for sale by owner to violate, I guess you could say, to discriminate. They allow, let me say that right. Federal allows the for sale by owner to not abide by fair housing rules. North Carolina, the FSBO is not exempt. The FRBO is not exempt. Other exemptions, if you own a dwelling and you or one of your immediate family members live in it, you don't have to abide by fair housing. Single sex dorms are also exempt. What questions do I have? That help hone it down a little bit. We're going to talk about the exam real quick and then we're going to break for lunch. But in the meantime, if you guys have a question that comes up during our lunch break, I just put my chat, or no, I put my number in the chat. So if you want to shoot me a text, I'll keep my phone handy. I certainly want to address any questions you may have between now and the time the test starts, because once the exam begins, I can't answer any more questions. So my number's in the chat.
16.
I'll be eating lunch too, but I can respond to a text. So what's going to happen when we come back from lunch? First thing that we need to do when we come back is I need to do a little check-in with all of you. I'm going to need to see your space. I'll let you have a blank scratch piece of paper if you choose. I know we're not doing math, but I know sometimes you guys like to doodle or take notes or draw pictures. So I will let you have a blank piece of scratch paper. I will need to see that scratch paper front and back. Make sure that it's blank. Of course, a pen, pencil, purple crayon, I don't care, whatever you want to take notes on your blank scratch piece of paper. I'll let you guys have drinks, snacks, cough drops, mints, gum, whatever. But I will need to see your space. So Sabrina will need to turn off your virtual background for the exam so I can see what's behind you. I think for the most part, everybody looks good right now. So I'll just need to be able to see behind you. Make sure there's nobody behind you giving the answers, right? That's why I can't let you have a virtual, a virtual background.
No, I know.
I also need you guys to, if you have your book or your textbooks, if you're the digital manual, this is where it gets tricky. If you're digital manual, I need you to log out. Okay. We'll talk about what tabs you're allowed to have open. But if you have your digital book with you, I wouldn't mind seeing it. So I know that it's with you. I know that it's nearby. Why do I want it with you? Because I allow you to take bathroom breaks if necessary. And I want to make sure this thing is not in the bathroom. I want to make sure that your notebooks, your flashcards, your cheat sheet is not in the bathroom. Okay. Is that fair? If not, then I have to say no bathroom breaks. That just seems really mean to me. So digital manual or your hard manual, you're either going to tell me, yes, Julie, I logged out, or this is where my hard manual is. Is everybody good with that? I also need your phones off. Again, I need to see it and I need to see that it's off. Are we all good in the difference in off and silent? I need them off. Please, before you log back on, go ahead and power your phone down So then when I do your check-in, you hit your button and I see that your phone is off. It used to be you guys turned it off for me, but that takes too long because the truth is none of us know how to turn our phones off anymore. So figure that out on your lunch break. And then when we check in, you can show me, you can hit the button and you can show me that this light doesn't come on and your phone is off. Do I have any questions so far? If you're on a laptop, I'm going to ask you to, pick your, show me your desk. Show me your clean space as best as you can. If you're on a desktop, I'm going to ask you to hold your right hand up and tell me that you have nothing on your desk area that be considered cheating. We have to go by the honor system in some cases here. Questions so far? No? Okay. As I mentioned, when we come back from lunch, there's only going to be 2 tabs open. You guys are going to log on to Zoom like we always do. That allows me to watch you take your test. Okay. I'll show you in just a second the mode you're going to see when you're taking your exam. Once I have everybody checked in, I will give you the link for the exam. So you'll click on the link, open your exam, and that's it, you guys. You can't have Google open. You can't have your digital manual logged in. You need to log out of your email once you get onto Zoom, right? Only 2 tabs open on your desktop. And again, this is an honor system. I'll show you in just a second how you can eliminate, how you can get everybody away. I just want you focusing on your test. So I watch Zoom, you guys watch Classmarker. Okay. Once the exam begins, I'm your only friend. I'm it. I'm all you got. Sorry. Once the exam begins, I am the only person that you can communicate with. No conversations with anybody else in your house or in the room. If I see you talking to somebody in the room, I can only assume you're talking about the exam. Okay. If you need to leave in front of your camera for any reason, you send me a private message. Never, ever, ever unmute yourself. If you unmute yourself, you're distracting others. And I do not like that. So you send me a private message. Julie, I have to go to the bathroom. Julie, I need to get more water. Julie, it's too cold in here. I'm going to adjust my thermostat. I don't care. I just need you to communicate with me via direct message while you're leaving your camera. What questions do I have about this? Never, ever, ever unmute yourself, except now. Yes, for a question.
Oh, no, I'm just thinking, you saying, with the moving the lips or something? Like, we talk to ourselves, don't we?
I understand that, but I can tell
Okay.
the difference in you reading a question versus you having a conversation with somebody in the room, right?
Gotcha.
I've been doing it. I'm coming up on 3 years now that I've been giving Zoom exams. So I'm not saying you can't get by with anything, but I'm watching you. Don't worry. And I can tell the difference. Don't
Great,
give me
okay.
reason to think that you're talking to somebody else in the room, right?
Gotcha.
So again, because if you guys are, you can only communicate with me and only me, right? Like you can tell you're reading a test question to yourself versus a full out conversation. Thank you because I know a lot of you guys do that. Anything else on this? Super important. Do not unmute yourself. This isn't for me. This is for your peers. Okay. So we do the check-in and I give you guys the link to Classmarker. Okay. You all click on the link. Once you click, you get an hour, 75%. Again, there's 32 questions. You have the ability to bookmark a question to come back to it. So if you read a question and you don't know, bookmark it so you can come back to it. We'll talk more about that in just a second. When you're finished, you're finished. You hit submit and boom, you see your results immediately. Once you're done, you can leave. You don't have to hang out. Once you're done and you see your results, you're welcome to exit Zoom. You and I both will then get an email with your results. So I'll see how you did as well. But once you're done and you see that, your results, then you can leave Zoom. You're all set. when you get the class marker link, you're going to be taken to a page that looks like this, only it's going to say 303 test, not pre-licensing test, but the verbiage is going to be the same. I want you guys to take just a minute and read this when you get your exam. This is saying that you're not going to use any device to cheat or share information. This is a closed book exam. You're not to discuss this exam with anybody. You know, myself, maybe Lane, but as far as your peers, maybe any of your coworkers, you cannot discuss this exam. So once you agree to this, then you'll be asked to either order, either put in your name and email, and then you see this, or you see this and put in your name and email. I don't remember which one comes first. So once you do those two things, then you'll be taken to the exam. The actual exam has one question per screen. So you answer a question and you go next. You do have the ability to go back. As we said, you can also bookmark a question so you can come back to it. Every single screen has a link on it that says see all questions. And the last thing you need to do before you submit your exam is to click on this, because this is going to tell you if questions are answered, unanswered, or bookmarked. So before you submit, you need to make sure that all of them say answered. If you don't answer it, you don't get credit for it. So make sure, take that extra second, click on see all questions and make sure it says answered. Each screen also has a countdown clock. So you start, you'll get 60 minutes and it'll count down for you. Don't stare at that clock, but use that, keep half an eye on it to make sure you're watching your time. If you're still around with about 5-10 minutes, I will unmute myself just to ask you to, keep an eye on your time. But you can as well. I know sometimes you guys get very focused, and I just don't want that time to get away from you. Remember, you guys, that email you got from Lane that you used to access this class, it's got a tutorial of Class Marker. And it's like 4 or 5 minutes, right? So if you haven't watched it yet and you want to know what Class Marker looks like before we begin, check that email from Lane. That may alleviate some concerns. Questions?
Once we complete this, will we still have access to LTP?
Yeah, I think Lane keeps it for 3 or 4 months, something like that.
Okay.
Yep. Another thing I'll do right before we begin, remember when I'm doing our check-in, I'm making sure that your paper is blank front and back, right? So I'm going to see both sides. Right before we begin, I will put my phone number in the chat again, and I will ask you guys to write it on your blank scratch piece of paper. So is everybody good with that? It stays blank, my phone number, and then we begin the exam. The reason for that is occasionally, sometimes you lose power, sometimes you lose internet. So if we have a glitch, if we disappear, if anything happens, first off, stop and breathe, take a big deep breath, but just call me. My phone will be right here. So if we have any kind of glitch in the internet or the power, just reach out to me. And that's why I want it on your paper, so you don't have to seek it out, right? So you'll have to turn your phone back on, give me a call. I don't know. I don't have a crystal ball. I cannot tell you what might go wrong. But what I do know is we will get through it. So take a big deep breath. Again, I've been doing this for 3 years now, almost. Hard to believe, right? I've had internet issues. I've had power issues, and we've worked through every single one of them. Okay. Everybody good with that? So I'll give you my phone number. If I can offer some last minute tips, I think the number one piece of advice I have to offer you is to breathe. If you guys feel yourself, oh my God, I've never seen this before in my entire life, stop, take a big deep breath. I promise you, it'll help center you. It'll help ground you. It'll help get your mind thinking straight again. So if you feel yourself getting, just breathe, put your pencil down, sit on your hands if you have to, close your eyes, but just take a few big deep breaths. Read the question, read the answer. Every single word means something. And then take your time, but watch your time. You don't want to leave a lot of time on the table, but you don't want to run out of time either. So just keep half an eye on your countdown clock. That's all I got. What do you guys got? What was that?
Lunch.
Lunch. Yep. We're going. So, all right. It is 1:16. Let's come back at 2. All right. We're all going to log out. We're going to come back at 2. I'll do the check-in. We'll probably get started, 2:15, 2:20, depending on, it won't take me long to talk to the 9 of you. So we'll get through that pretty quickly. And that's all we got left is a test. So y'all don't eat a buffet style lunch. I don't want you to come back sleepy, right? So just get a light lunch, get you some caffeine or whatever you need. And we'll come back at 2 and knock this out. Sound good? All right. Enjoy your lunch.